Item 49 of notice supplementary list. So you may be allowed to bring the same on record. Public.
That is that one.
Yes.
I told the other side counsel that day about this thing.
May it please,
Hmm.
my lord, one matter, RSA, my lord, it was in the list for hearing. I did not reach, my lord. Can you lordship take it on 31st?
No. Absolutely no. It's for hearing.
Well.
31st is last day.
As convenient to your lordship in the next.
No. First hearing, how do you mention it? I tell everybody that you cannot mention a hearing matter. I can't help you. You can ask her. It's an old matter.
Very old matter, 2012.
2012. Ask the registry to list it next week somewhere. But for me to give you a permission out here would be opening everybody. I don't give mentioning for hearing.
All right, my lord, throw it. Obliged. That item 2, my lord. No problem with this. We take on either Friday or Monday. Any other day. Either Monday or Friday. Item 2.
Why?
Today I have some problem, my lord. There was
Mr. A. Rashid, the learned counsel appearing on behalf of the petitioner, seeks for an accommodation for today to list the matter on 3rd of June.
Lordship, I beg to mention for listing of RSA matter. This is the 2017 matter.
For what?
For orders to bring up for hearing.
Huh?
For orders to bring up for hearing.
It is already fixed for hearing?
No.
Okay. Next week, 10th. 10th, no, 12th.
With respect to item number 45 of 86, I have filed the affidavit on record. I have
Item 8.
Yes, you don't want to do it today. At the request of the learned counsel for the appellant, matters can be adjourned to be listed after 2 weeks.
Lordship, I beg to mention on item for listing in order called.
What? What is that
RSA
matter?
RSA matter, Lordship,
For
for orders, Lordship. You have to file one IA.
IA. Okay. Then 12th.
Actually, one IA is already pending. You want to file one more IA for substitution, Lordship. Cited
You have already filed it.
another appellant, like one more appellant.
Understood. You file it. It will come up on 12th.
May please, Lordship. Lordship, in item number 40, we have filed our affidavit, Lordship. Yesterday, Lordship. That may be possible.
Okay.
Public.
But I have instructions to withdraw it first.
Withdraw.
And-
The you have always been taking adjournment in this.
Because earlier we had taken adjournment. because there was
All
some
the
talk of
along it has
compromise
been
going on.
adjourned.
Yes.
1, 2,
They have not
3,
accepted.
4, 5. Mr. G. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant petition. Taking into account the above, the instant application, instant revision petition, which is directed against the order dated 2/6/2023, passed in title execution case number 5/2016 by the court of the learned Munsif Punitpur. Huh?
Now it is civil judge.
Learned Court of the Civil Judge. Junior Division.
Senior.
It has gone to senior.
Yes.
Civil Judge. Punitpur at Tezpur. Stands dismissed on withdrawal.
Keep you.
Deputy. File it as a type.
You don't have bank account? Huh?
It's not available. Maybe
He says none. Is it conceivable nowadays? You are doing a particular business and you don't have a bank account?
I thought available.
Then this affidavit of assets is false. How is it possible that you cannot have a bank account? What is your business? Salesman.
I am the hardware shop.
You are the owner of a hardware shop.
My brother-in-law. My brother-in-law is the owner of the shop. My brother-in-law.
Your name is Ankur
Ankur
Kakoti. Kindly come to page 80.
It's
80. Details of the income of the deponent. Name of the employer is Ankur Kakoti, who happens to be the petitioner. So you are your own employer, means you are not working under anybody.
designation is self.
Huh?
Designation is salesman.
So what? Employer, name of the employer is who? You may be at best an employee, but you say that you are your own employer.
I am the employer.
You have not stated you are you say yourself to be the employer. What does AK Enterprise stand for? Ankur Kakoti Enterprise.
No,
Then
Ahina Kalpo Enterprise.
Then you yourself consider yourself to be the owner.
I have the
No, this is a
correct.
certificate which he has signed it. Either this document is false.
These are things that I am the employee of this company actually. You think about this.
It is not mentioned name of the employer. Then and you don't have bank accounts.
I'm not actually aware about.
No, you have filed it. And you say that you don't have a bank account. This is conceivable nowadays that you may not have a.
I have no that I'll give it.
And you earn 8,500
500
and you spend 6,000.
to my parents is with me.
6,000. So is it possible to think about that you are living with only 2,500 in a month? Is it conceivable?
I thought I am a purely at a village man. I have no any other expenses actually. I'm
You,
purely village man.
you categorically say out here in your affidavit of assets, the approximate expenses incurred on account of the
6,000.
dependent, who are your parents, is 6,000. Kindly come to page 79. So this is a false document.
What a false document. I actually expended 6,000 with my parents. My parents is with me.
So you spend 6,000. You earn 8,500.
Because I am the my father is dependent on me now.
Understood. So you spend 6,000 on them,
My medicine is there and other.
and only on 2,500 you are surviving. Is it possible?
I'm a completely village poor boy actually.
Huh?
I'm a completely village poor man. The boy. That's why the girl left me. actually.
You are?
I'm poor. The poor belongs for poor family. My father is the employee. I am not the. My father is the serviceman, but I am the worker. So that my father is the
Your father is a serviceman.
ex-service.
Ex-serviceman means
He's working in public health or otherwise.
he gets his pension.
He gets his pension.
Then also he takes your money.
Yeah, I did not took money from my father.
You are spending 6,000 on them out of 8,500.
I don't.
Then
Yeah.
don't come up with all these false excuses before this court. This affidavit of assets is completely false.
As per his version, I was
Whose version?
Uncle Kagat, the petitioner.
The petitioner's version, if it is true, then he says himself to be the employer. File your affidavit of assets in respect of AK Enterprise. We'll consider that income is your income. Because you are saying that you are the employer. You want to file a fresh one? A fresh affidavit of assets? Or we go by this?
But I felt quite pissed.
Better
I
off.
want to ask him about the bank statement.
Yeah.
I have no.
The learned counsel appearing on behalf of the petitioner submits that there seems to be some discrepancy in the affidavit of assets so filed to the additional affidavit of the petitioner. He therefore submits that she may be permitted to file a fresh one. How much time?
15 days.
15 days time is granted for that. This is the matter on 19th of June for motion.
I live this.
Yeah. What is this?
If they have challenged two order in this case.
Hmm?
They have challenged two order.
What order?
One, they have called for some sell dates, and another is some record from the GMDA.
Which order there? Which other order?
Page
Will-
number 42.
42.
42.
Plaintiffs and the heirs of so-and-so represented by Tokara today, they have filed an application on 16/2/8 to continue to cover. So this is the order at page 42.
42.
They're challenging.
They are challenged.
Okay.
In fact, it was dismissed for precipitation on last time, Lordship.
Okay. Don't worry. None appears, but then also, this is 227.
226.
Okay. I can very well dismiss. None appears on behalf of the petitioner on call. Mr. G. Bharadwaj appears on behalf of the respondent. It is seen that on the earlier occasions also the petitioner had not represented, for which the instant proceedings were dismissed for non-prosecution. However, subsequently, by an order dated 4/4/2023, the proceedings was restored. In spite of that, none has appeared on behalf of the petitioner on 28/4/2023. Today also, none has appeared. Under such circumstances, this court takes up the instant proceeding for disposal. The instant petition has been filed challenging the order dated 28/3/2018 passed by the learned Munsif number 2, Kamrup at Guwahati in title suit number 37/2013. A perusal of the said order shows that the petitioner,
Petition. Petition. Sole petition.
the petitioner herein, who is also the plaintiff, had filed 2 applications before the learned trial court. The first application is an application under Order 16, Rule 2 of the Code of Civil Procedure 1908, for short the Code, for calling for issuing summons upon the senior sub-register Kamrup Metro for production of various original sale deeds, numbers 3045 dated 22/2008, sale deed number 5652/2000 dated 7/8/2000, sale deed number 2752/99 dated 7/5/99, sale deed number 10191/05 dated 22/8/2005, sale deed number 2346/98 dated 14/5/1998, sale deed number 2763 dated 7/5/99, and the power of attorney being deed number 972/05 dated 17/2/05. Full stop. In addition to that, by another petition, which is under Order 13, Rule 10 of the Code, the original record of land sale permission by number 1056/05, bearing file number 1056/05/25 dated 27/6/2005, was sought for the GMDA, Dhongagar. The learned trial court, by the order dated 28/3/2018, rejected, partly allowed the petition number 2949, thereby directing calling for the official witness from the office of the senior sub-register Kamrup Metro in respect to the sale deed number 3045 dated 22/2008.
Yes.
However, the learned trial court rejected in respect to calling for the originals of the other sale deeds on the ground that there is no pleading in the plain in respect to those sale deeds. In respect to the petition number 2950, the same was also rejected on the ground that there was no mention in the pleadings as regards the said sale permission. This court finds it very pertinent at this stage to take note of the provision of Order 7, Rule 14 of the Code, which stipulates that if a plaintiff sues on a particular document, sues or relies on a particular document, the said document has to be enclosed along with the plaintiff. It is also mentioned that in the circumstance the plaintiff is not in possession of the said document, it has also to be mentioned in the plain as to in whose possession the said document is. In the instant case, the learned trial court have rightly passed the impugned order. Inasmuch as when there is no mention about those documents, more particularly the other sale deeds or the sale permission in the pleadings, the question of issuance of any direction to the authorities to produce those documents was not necessary. Accordingly, this court finds no merit in the instant petition, for which the instant petition stands dismissed. This court further takes note of that by an order dated 24/5/2023, the further proceedings of title suit number 37/2013 was stayed. The said order stands vacated, and the parties herein are directed to appear before the learned trial court on 15th of July 2024. So taking into account that the petitioner is not present today, the learned trial court shall issue due notice to the petitioner oblique the plaintiff before further proceeding with that.
Ideal.
Yes.
My lord, this is a petition, my lord, for appeal, my lord, under section 28 of the Hindu Marriage Act. Against the divorce granted by the,
What is the other one?
this is the first time it is listed.
Is it stay?
Yes, the petition for state. So the only two grounds has been, my lord, appreciated by the learned court, my lord, that is suggestion and
Okay, appeal admit call for the record to notice the text within 3 days by registered as well as usual. List the matter for hearing immediately after completion of the service and receipt of the records. I cannot go. This is an application under Order 41, Rule 5 of the Code of Civil Procedure challenging the judgment and decree dated for stay, seeking stay of the judgment and decree dated 16/3/2024 passed by the learned district judge Dibrugarh entitled to divorce number 15/2019. Yes, which is the provision out there, which is an automatic stay. Hindu marriage act. Is a Hindu?
yes, it,
Hindu marriage. What is that provision? Taking into account the provisions of Section 15 of the Hindu Marriage Act 1955, and as the appeal has been duly presented within time, this court is of the opinion that that till the disposal of the instant appeal, the judgment and decree dated 16/3/2024 passed by the learned district judge Dibrugarh entitled divorce ES divorce number 15/2019 shall remain stayed.
Alright.
I Yes, what is this?
And the Senate court below has granted injunction matter, where the bona fide person. The plaintiff is not in the possession over the land. The difficulty faced by both sides has to be considered while granting injunction matter.
What is the injunction given?
Yes, madam, page 77, sir.
Page? Who are you?
Well, I am the defendant number 1, my lord. I purchased the land from defendant number 3, 4, and 5.
Okay, we issue notice only. Appeal to Tibo. Heard Mr. B.K. Das, the learned counsel appearing on behalf of the appellant. You have urgency?
Yes, my lord, because construction work was going on. And without ascertaining who is in position, there is no statement in the plain. that
What
he
is the
in
suit
possession.
for?
Suit is for right title declaration in respect of 1/5 share of the land. In respect of.
How did you acquire the land?
Yes, my lord. That the land was already my lord partition. It is opposed partition. My lord, agreed partition. Lordship, just for a moment, my lord. Page 52. It is in Assamese. Sopro Bikoyer 29/6/2018. Tarikor opposed Batuara number. My lord, circle Tini Bigha, Tini Kotha Matit. These are the defendant number 2, 3, 4, and 5, my lord. My lord, the plaintiff has already, my lord, obtained land in excess in other plot of land. This is the case. He also, my lord, in there is another suit was pending. He has annexed in the plaint, my lord, that suit. Suit was filed by defendant number 2, 3, 4, and 5, my lord. That lordship
Where is
earlier
the
suit,
plain?
para 6.
Where is the plain?
Yes. Plaint is that page 14, my lord. And lordship para 6. This is the suit I filed, 557/2020. For he has quoted everything. And my lord, page 17, my lord, last 3 paragraph. That to be mentioned, my lord. And my lord, last 2 paragraph, my lord, that the defendant has obtained more land, which includes other land situated different places, and accordingly, he has been approving said land and some of the lands. My lord, here defendants mean, my lord, the plaintiff in this present suit. He has admitted, my lord, by placing the earlier plaint in his plaint. And now, my lord, page 18, 4th paragraph, it is also important, my lord. Lord, there was also a police case. There, my lord, he appeared on 28/2/2012. 4th paragraph, my lord.
The plaintiff is not the son of the Toliko Pukon.
He is a son, 2 sons.
Ah.
I am the elder one. He is the younger. Now, thing is that here, my lord.
You are elder mean?
My lord, sir. My
You are a company.
my husband. Sorry, I'm the defendant number 2, my lord. The husband of defendant number 2, my lord, Diganto and Pranjal Pukon. They are the brothers. Now, thing is that, my lord, Apus Batwara, my lord, agreed the partition was there. There was notice served, everything was served, my lord, and land was meted
Then
on
you sold your
29/6/2018.
Then you sold your land.
Yes.
Then
And at the time of, my lord, I purchased, there was no dispute. The land records are
when did you purchase?
yes, I have given just my lord. 21/6/2019, my lord. Page 34 is the cell. We obtain a sale permission. We have gone, my lord, circle officer, as to the entries made therein. There is no complaint, my lord.
You're a government of India, Assam company.
My lord, yes, this is my lord, joint venture company.
Which?
NRL.
We do one thing, we issue notice, making it returnable. When do you want?
I will take.
19, Justice Service,
I will,
we dispose it off
my lord.
on that date. But without appearing, when they have an injunction, without their appearance to stay, it would not be.
Only I was saying, my lord, that without ascertaining who is in possession, there is no mention as to in the plain. Without having possession,
No,
Court-
no.
would not have grant.
No. Whether you, for example, you are in possession. Let us assume that you are in. What is the injunction? Injunction
for
that you
status
should
quo
not
in-
construct.
Yes,
Meaning thereby, it is an admitted fact by the plaintiff that you are in possession. Otherwise, how will you construct?
Right.
The trial court says that in the circumstance, if there are triable issues, but if residential quarters are made, then in that regard, it becomes irreparable. Therefore, construction has been stopped. The order does not seem to be bad, but the thing is, the learned trial court ought to have put some conditions.
yes.
Tomorrow, who is going to pay the escalation cost?
That's right.
Yeah.
My lord, yes, correct.
Will issue notice,
Right.
notice, without a notice for you,
Right.
huh? And it will go step by registered as well as usual within 3 days. Returnable on, you want a early disposal?
My
19th of June. Step by way of the, in addition to that, the petitioner appellant is also married to take steps by way of custody, rooted to the registry of this court, and file an affidavit of service by on or before the next day. You cannot there, you cannot notice, not to the
on the next day, lawsuit will consider the
Huh?
if on their appearance, matter. My lord, IA may be considered on the IA proceed.
If I am sitting, I will dispose. If I am not, I can't.
Okay.
I cannot agree. The fair prosody of the order that we consider. The next. Yes, what is this?
On 6/12/2023 lordship.
Hmm.
Matter came up before the honorable court lordship. I was asked to my lord submit my lord that my substantive question of law. My lord, my lord, case is not the appellants with plaintiff lordship. They filed my lord instituted title suit lordship for right title interest, my lord. My lord, eviction and injunction law. My lord, the property was their paternal property. Lord. The pleaded case is lordship. The respondent's lordship, in collision with the my lord, the revenue authorities lordship.
You are a plaintiff?
Yes, Lord.
Yes. What is your case?
My Lord, the property, my Lord, the petitioner's paternal property, Lord. The pleaded case was, Lordship. The respondents, my Lord, in collision with the, my Lord, revenue authorities, my Lord, got recorded their name. And we're in position for full position. My Lord, the defendant's Lordship, their pleaded case is that they purchased the land, my Lord, from one, my Lord, Kiran Beva. My Lord, without, my Lord, during evidence, my Lord, the defendant did not exhibit the original shall deed loss, only photocopy loss. My Lord, those were exhibited on the basis of that, my Lord, their right title and has been declared loss.
No. Did they file a counterclaim?
No lordship.
So,
But the written statement, my Lord.
we are not concerned with that. But did you prove your case? We are concerned with your.
In the written statement.
No, forget about written statement. Written statement is next.
My Lord.
Did they admit? First, there are two ways.
Yeah.
Prove it. Did they admit in the written statement your title?
Not it.
So, burden lies upon you to prove that you have right title and interest.
No.
Do you have? What did you prove? What did you prove?
My Lord, PW3 loss.
Okay,
Now kindly see page.
How did
61.
you get the title?
My Lord, page 61 loss.
No.
Yeah.
How did you get your title? Tell me.
Title, this is my paternal property. PW, my Lord, PW4, my Lord, PW3, my Lord, the
Okay.
official witness.
It is your paternal property.
Yeah.
How did your paternal property get that person, your father or your predecessor
Yes,
of the father got the title? How?
Father, my Lord, on the right of inheritance, lordship. My father got.
So there must be issuance of patta.
Yes, that should be there.
Did you enclose the patta? Bring on record the patta?
My Lord, it was not. My Lord, the revenue authority, my Lord, revenue authority, my Lord, the was examined, Lord. PW3 stated that the land, there is a record, land on record, my Lord, in the name of the, my Lord, petitioner's father, Guardianship, Lord. That was not discussed, that is ignored, my Lord. On that count, it is perverse.
That's a revenue entry.
Revenue entry, Lord.
Now, whether a
And
revenue.
Their case, Lord, their case is that they have purchased from them. They did not, my Lord, deny. They did not deny that it was not the petitioner's paternal property. When this statement is not denied, my Lord, the paternal, my Lord, ownership of my father-lordship is not in dispute, Lord. So, right of inheritance, Lord. Right of inheritance, it is also not disputed. Their plea is they have purchased the land from my father and my Lord, grandfather, my Lord, grandmother. Lord. My Lord, this is their case, Lord. So,
Show me the written statement. What it is?
yes, page 16, Lordship.
Page 23.
Yes. Reaction of the deceased defendant number 1, Habibur Rahman.
Where do they say that they purchased it from your father?
This is the, my Lord, page 16, kindly see.
Where is your?
Page 16,
Who is your father?
Zoinuddin, Lord.
Huh?
Zoinuddin.
Guardianship. Say.
Page 16, my Lord.
Okay, wait.
The contents made in the
That year in the year when so the landowner Zoinuddin Sheikh died, leaving behind his wife Mutu Bega. The plaintiff number 1, 3, Where do they say in the defendant that they purchased it from whom?
My lord, page 17, Lord, it is stated, Lordship, land, that numbers, page 17, next page.
Where?
The rest of the land measuring 4 katha, 17 lessons covered by that number so and 4 katha, 10 lessons covered by that number 544 slash 655 was in the ownership of Zainuddin Sheikh, and Zainuddin Sheikh during his lifetime sold out 12 kali land of 4 katha, 17 lessons mentioned in E schedule, part of A schedule to the defendant number 1, Habibur Rahman. Zainuddin, my lord,
I
ownership.
registered sale deed number so and so by delivery of possession.
Yes, sir.
Sold out his state portion of land to so and so.
So, my lord, ownership of Zainuddin, my lord, is not
What is 12 kali?
12 kali lordship. It is in the district, Dhubri district lordship.
What?
I have
You are the plaintiff, you are the appellant, you have to say.
that measurement lordship.
Huh?
Actually, herein it is katha lordship, 4 katha. Out of 4 katha, 12 kali lordship. This is
Let us see how the trial court goes.
now page 61 lordship. Points, my lord, were framed. It was decided point was lordship, page 61, 3 points were framed. Page 61 kindly see lordship. My lord, point 1 and 3 lordship.
So did you put an objection to the photocopy of that document?
That was not objected.
What?
That was not, my lord, photocopy lordship. My lord, that is not admissible in
Oh.
court.
Who says? Who said?
My lord, photocopy, my lord, it is not a public document, lordship.
Hmm.
Private document,
So?
lordship. It is not a applicable.
Why?
This guy,
Why?
my
Tell me,
lord,
give me-
how
give me
it
a
will
good-
be pro
Huh?
plot? Photocopy, how it will be pro plot? Certified copy, my lord.
No, no, a
Certified
photocopy.
copy. Had it been certified
Photocopy
copy,
not possible.
it was not pro plot.
Let's see, read section 63.
Section 63, as per section 63, it is not pro plot. Section 61, lord.
Hmm? Secondary evidence is what? Section 63.
Well, secondary evidence certified copy of original, lordship.
So,
It is not a certified copy, lord.
kindly have a read. What is section 63? Section 63 is primary or secondary evidence?
Proof of documents, 61, my lord, document evidence policy. Proof of documents, my lord, the contents of documents may be proved either by primary or secondary evidence.
Okay.
Primary is, my lord,
Come to secondary evidence.
my lord, secondary evidence. Primary, secondary evidence.
Hmm.
Section 60.
What does it say?
Secondary evidence means an enclosed certified copies given under the provisions hereinafter contained, copies made from the original by mechanical process which in themselves show the accuracy of the copy and copies compared with such copies. Copies made from or compared with the original. Counterparts of documents as against the parties who did not execute them. Oral accounts of the contents of a document given by some person who has himself seen it.
And what is the second illustration there?
Second illustration.
Hmm. There are illustrations are there, no?
B, lordship.
B.
A copy compared with a copy of letter made by a copying machine is secondary evidence of the contents of the letter. If it is shown that the copy made by the copying machine was made from the original. My lord, nothing is here, lord.
There. Kindly come to page 40, paragraph 22 of the trial court judgment.
TW1.
Yeah.
TW1 has submitted the photocopy of sale deed number so and so, which has been marked as Exhibit H. In order to prove Exhibit H, defendant has adduced the evidence of TW4, official witness who has verified its contents to similar with the official record.
So,
It is
then
lordship.
you should have put an objection. It could not have been done.
My lord,
You
it
did
might
not.
put submission. It should be, my lord, verified from the office, lordship.
What?
My lord, certifying, my lord, but the official.
It is not required to be
official-
certified. A photocopy of a document can be given as secondary evidence. There's no quarrel, but you have to only show that this is from the original. It has been photocopied from the original. This is what is the mandate out
Then, my
there.
lord, maybe, my lord, taken up other day, I'll, my lord, satisfy you thought
Ah,
on that point.
not satisfied. Okay. Pursuant to the order dated 6/12/2023, today the matter has been listed at the stage of Order 41, Rule 11. Mr. M.H. Amit, the learned counsel appearing on behalf of the appellant, have submitted certain additional substantial questions of law. This court, prima facie, is not satisfied with those substantial questions of law the questions of laws which have been proposed to be substantially involved in the instant appeal. The learned counsel appearing on behalf of the appellant seeks for an accommodation. It's the matter of 2 weeks.
All right. The other 2 points, lordship.
Huh?
Not challenged, lordship. The issues not challenged, so my lord, that is debarred. Issues, my lord, which are not challenged, lordship. My lord, my lord, findings on the issues, issue number 1 and 3, lordship. Those my findings were not challenged by the, my lord, respondents for the lordship. That has been
my lord, required. So that is uncalled for. Without any-
Number 1 and 3.
1 and 3, my lord. That findings, maintainability and non-gender and my lord, letter and non-letter of necessary party clauses. My lord, the usually in favor of the my lord plaintiff clauses. My lord, without any silence clause, you learn first appellate court that has been my lord reversed clause.
Mr. Let me ask you one thing. The trial court, if the trial court decrees the suits or trial court holds that yes, there is the cause of action, the first appellate court thereupon, upon appreciation of the facts, find out that in respect of other issues, there is no case made out. Then obviously, on a true understanding on the concept of cause of action is there is no cause of, because
That is on merit
what
first.
the learned trial courts have been doing out here, as I could see in all the judgment, if you have a case for going for trial and the other side opposes it, they think that to be a cause of action. That is not a cause of action. That a cause of action is are those material bundle of facts which entitles the plaintiff to a relief in the suit. That is a cause of action. And this basic fundamental, the trial courts, they don't understand. The first appellate court was therefore right in doing so.
Okay, dear lord. All right.
Mm.
I'll try, lord.
Yes.
I prefer an accommodation for a day, my lord.
Ah.
Medical emergency of my senior, my son.
What happened to your senior?
No, no, his son had to undergo operation of eye.
Huh?
Operation of eye.
Who?
His son.
Hello. At the request of the learned counsel for the appellant, the matter stands adjourned to be listed. Not yet framed after the vacations. Mr. M.J. Ahmed, the senior counsel, appears on behalf of the. Okay. None appears on behalf of the appellant on call. It is also seen on the earlier occasion also none has appeared on behalf of the appellant. Taking into account the above, the instant appeal stands dismissed for non-prosecution. I stand also dismissed in the dismissal of the company. I to collect.
Arguing counsel is in difficulty, they are unable to come.
Your arguing counsel is where?
In morning he's supposed to come, but due to some problem,
Flood. You never know, the cyclone may just be hitting on near place where your arguing counsel may be residing. Is that the reason?
No.
Then? Why is he not here?
He instructed me to take time, but with some problems, unable to come.
Okay. At the request of the learned counsel appearing on behalf of the appellant, the matter stands adjourned to be listed after the summer recess.
Hello.
Two of it. Thank you.
Very different. But my senior is like in court number 13.
Huh?
Court number 13. Like court number 13.
This matter has been pending from 2010. And your senior is not around. Then on the last occasion also, your senior appeared and could not satisfy this court. What to do? You dismiss it. There has to be a closure. Whether the deed numbers so and so are forged, fraudulent, and obtained by playing undue influence. My goodness. Can that be a substantial question of law? Another. As to whether any declaration of gift from performer defendant in respect to the suit land and acceptance of the state gift by the principal defendant as well as delivery of the subject of gift. Huh? What is this? Muslim? Okay. In respect of suit land, the gift by the principal Muslim possible? 124, 149. Whether plaintiff have any share over the suit property. Right? Can that be a substantial question of law? As to whether the testimony of PW2 is sustainable in law. Right? Yes. Today, the learned counsel appearing on behalf of the petition appellant have placed before this court a set of questions of law, proposing them to be substantially involved in the instant appeal. The said substantial questions of law, the questions of law which have been proposed, this court prima facie is of the opinion that the same cannot be formulated as a substantial question. However, for the ends of justice, matters can be adjourned to be listed immediately when after the summer recess. Please stay. No stay. No stay. No one appears?
Your Lordship, I am very correspondent.
What is the case about?
Your Lordship, the petitioner challenged Your Lordship the order dated 24/3/27. Your Lordship. In title to Your Lordship.
The case is pick for hearing on the Yes, Mr. Scott. We allow this petition. Unnecessary. Is it 2010 suit? Let him be cross-examined matter ends out. None appears on behalf of the petitioner on call. Mr. D. Chaudhary, the counsel appears on behalf of the respondent. This is an application under Article 2 to 7 of the Constitution, challenging the order dated 24/3/2017, passed by the Court of the Civil Judge number 1, Kamrup Metro. Guwahati, na? Kamrup
Right.
Metro at Guwahati. In title suit number 148/2010, whereby an application filed under order 18-17 of the Code of Civil Procedure for recalling the plaintiff witness number 1, whose evidence have been closed, was rejected. This court had perused the order dated 24/3/2017, which have been impugned in the instant proceedings. From a perusal of the said order as well as the application which was filed by the petitioner, it is seen that on 6/4/2016, the case was fixed for cross-examination of PW1. The counsel for the defendant had duly submitted the hazira, but during the pendency, but at the time when the counsel for the defendant had gone out of the court, the evidence of the PW1 was closed in view of there was no counsel present to cross-examine the PW1. It is under such circumstances an application was filed for recalling the order dated 6/4/2016 and thereby permitting the re-examination, the cross-examination of the plaintiff witness number 1. This court further takes note of that the learned trial court observed that recalling of the said order can only be done when there is a mistake committed by the court. And as there was no mistake so committed by the court, the learned trial court rejected the said application by the impugned order. It is under such circumstances the present petition has been filed. This court have also taken note of that on the earlier occasions, the plaintiffs were granted various opportunities. And on 6/4/2016, the plaintiff, the defendant, counsel had duly submitted the hazira. However, at the time of this court also finds it very pertinent to take note of that in the trial courts, the matters are not taken on the basis of a list, list serially, but are taken out of turn whenever the said matters are put up before the court. Under such circumstances, there could have been a circumstance where the defendant counsel may not have been present at the time when the file was put up before the court. The order which have been passed, thereby closing the evidence of the PW1, in the opinion of this court, affects, seriously prejudices the defendant for no fault of the defendant, and at best, some fault of the counsel. Under such circumstances, this court therefore interferes with the order dated 24/3/2017 and directing and thereby allowing the 24/3/2017 and directs the learned trial court to fix a date as per the business of the court for cross-examination of the PW1. This court also takes note of that by an order dated 9/6/2017, the further proceedings of title suit number 148/2010 have been stayed. The said stay order stands vacated, and the parties are directed to appear before the learned trial court, that is the court of the civil judge number 1, Kamrup Metro at Guwahati, on 15/7/2024. On that date, the learned trial court shall fix such date as per its convenience of its business for cross-examination of the PW1. It is however made clear that taking into account that the petitioner is not represented in the instant proceedings today, the learned trial court shall also issue due notice to the petitioner about the matter being pending now before the learned trial court.
This is the revision application for the railways matter against order passed by the learned RCT matter, railway claims tribunal. What has happened in this case? Matter?
Where is that order?
That order not at page
57.
57.
57.
Oh, you don't know.
No, it's 32.
Order sheet 57.
54 is the main order.
Huh?
Page 54 is the main order. Thereafter, there are other orders.
Which order you are challenging?
54, my lord.
What is that?
What has happened in this case, my lord? There was a direction by the railway claims tribunal to pay compensation to the respondent number 1 hearing. On that amount, certain interest was also made payable. We had calculated the amount, and the interest payable came to around 3,89,000 something. Now, in terms of the income tax department's direction, we are required to deduct TDS on the interest amount if the interest amount is more than 50,000. And in case the person who is entitled to the compensation amount, he doesn't provide the PAN number, we are required to deduct it at the rate of 20%. We have deducted the amount and deposited that TDS amount to the income tax department. Now, the claim of the petitioner is that since he is a person belonging to the state of Arunachal Pradesh, he is not liable to pay income tax. So, we could not have deducted the same, and he filed an execution petition before the RCT, and RCT directed us to refund them. Now, this deduction of income tax at source, my lord, was done in terms of the
Wait. The person belongs to which community?
It's a firm, my lord, capital firm, proprietary firm.
Oh, which community?
He says he belongs to Scheduled Tribe.
Scheduled tribe, which community?
That's a
What is your?
Doctor, I am put a performer from the department. The standing counsel senior, he is on legs on a court number 1. Doctor.
Who?
Mr. H. Chetia.
No, we are not concerned with him. Who is appearing for the respondent?
none is appeared, my lord. We have taken steps twice, my lord. The AD cards have returned back. Before the tribunal,
Now what happened? There's an order you have complied with, you got to stay.
Yes.
What is the name of the
capital,
person? Who is the respondent? Let us see the name of the person.
page 2, my lord.
Capital Hardware.
Enterprise.
Who is the proprietor?
Proprietor.
You see, if it is a proprietorship firm, then in that case, that person would be there. Now, you see, the income, the interest income accrued where? Where? In Guwahati? In Arunachal? In Delhi? Where? His entitlement to receive the amount is here or is in Arunachal Pradesh?
What has happened? He booked a consignment of cement for transportation by the railway. Now,
Till
NLP, New Lakhimpur. That is in.
So it will be in Assam. If it is in Assam, whether the tribe has been recognized in Assam, all tribes are not recognized. So all Arunachal tribes are not recognized here. Similarly, all tribes out here are not recognized in Arunachal. And if it is not so, then he would not be getting the benefit under 1026 because 1026 says that the benefit has to be given to those scheduled tribes where the income accrues in the area where it is a scheduled tribe. Isn't it? In fact, there was a matter out here while I was a lawyer, we did it. There were a lot of people from Boroland area. They were employed in BRPL this side. This side is a scheduled area, not this side. You have to also get the income from the scheduled area. The BRPL's Dhalgaon is this side, which is in Bongaigaon, which is not a scheduled, and therefore they don't come within the ambit.
I've got an additional ground.
This one I give you.
But from what has fallen to your logic, because that person is from Arunachal, probably you would not be recognized as a scheduled tribe in.
You may not know, but every state has their own. And whether that area is there.
Anyway, my lord, this
Anyway.
judgment was done in terms of the income tax department's directive.
No, you see, there is one judgment. The judgment, I think, of us, another coordinate bench, where it held that if an income is exempted, there is no question of deduction. Some king ceiling or something, if I remember the name. Have they referred to that? King ceiling or something? That is the law. I have not referred. That is a judgment of Justice Ranjan Gogoi, as he was there. So, this is the basis that if it is exempted, there is no question of deduction because there will be only a case of refund. So that is the basis on which they are doing it. But to be exempted, the income also has to accrue from in that area, which is exempt.
Anyway, my lord, I'm asking you myself, this case, the amount has already been deducted and deposited with the income tax department. Even assuming, my lord, he is entitled to get the benefit.
But how do I dispose of the matter without the other side being present?
They are not appearing, my lord. That's the problem.
No, you have to service unserved notice received back with posted addressee not known, so and so not known. I think you take steps by way of this thing, paper publication in that area, Arunachal. You'll file an application. File an application for substituted service. Okay. Mr. B. Sharma, the learned counsel appearing on behalf of the petitioner, submits that in spite of various attempts, the petitioners have not been able to met out service upon the respondent. He therefore submits that he may be permitted to file appropriate application seeking substituted service. So taking into account the above, list the matter again on 29th of July 2024. In the meantime, application be filed for substitute service. Interim order passed earlier shall continue.
Respondent two lot.
What?
Respondent not two lot.
You are who?
Income tax department.
You are income tax?
Lot.
You are a panel lawyer?
No, lot. I am appearing on behalf of.
No, don't appear on behalf of, you can't. This is a department, kindly appreciate.
Like he is on legs lot.
Whatever may be. He is on legs. You cannot appear for department. Like, yes, tell me.
This matter pertains to the transfer of the restitution petition from Family Court Dhubri to the District Court Bongaigaon. As the wife resides in Bongaigaon and their marriage also solemnized in Bongaigaon. Your Lordship.
The last
Yes.
resided together at Bongaigaon.
Bongaigaon. After that, they have shifted to Dhubri.
Hmm?
But after that, they have shifted to Dhubri.
When?
August 2021.
So what is your difficulty?
But it is.
What is your
petitioner
difficulty?
Unable to contest the case at Dhubri.
Why?
Maybe this there is section 19 of Hindu Marriage Act. It tells that every petition under this act shall be presented to the district court within the local limits of whose original civil jurisdiction. The marriage was solemnized. But the marriage was solemnized in Bongaigaon. Lordship. The respondent at the time of presentation of the petition resides at the time of presentation of the petition. The respondent, that is Rinki Bhaduri, was staying in Bongaigaon. Lordship, the petitioner wants to transfer this restitution.
No. You are missing the in-between subsection where the both resided last time together.
At Dhubri.
You stayed from 2020, August till October. Then why you are missing out that?
But Lordship, in the principal just family court Dhubri, the petitioner has to present there personally.
What is your difficulty?
Difficulty to travel, Lordship, from Bongaigaon to Dhubri.
Why?
Apprehension of physical harm by apprehension of physical harm by the respondent.
For that, file an FIR. Then?
Lordship, in the district court, in the district judge Bongaigaon, the petitioner The advocate can also appear in the matter, but in the family court, we have to
Transfer করে দিব। You file your written statement? No. File your written statement on 15/7 before the court at Dhubri, district judge. Transfer. Difficulties are there. There are difficulties out there for here. The petitioner says it is the case of the petitioner that she has no source of income. You have no source of income. No. And it is difficult on the part of the petitioner to contest the said case from Dhubri. Apart from that, the petitioner also alleges fears that each and every time she has to appear before the principal and before the family courts at here, there is a fear, apprehends fear to appear before the in view of the fact that the petitioner have fears about her safety to appear before the principal family, before the courts before the family court at Dhubri, taking into account that the petitioner personally has to appear before that state court. Taking into account the above, it finds sufficient ground for transfer. Right. Your name? Give your name. Yes, who is appearing this matter? What? You do the matter. Is there? Whatever matters, you don't request any. Which order you are challenging? Yes. What is your suit for? Hmm? Yes, tell me. Yes. What is wrong with the order?
Why not the matter?
Bye.
My senior is in PMLA. Senior is in the PMLA.
Is that what do I do?
That may be passed.
You don't have a case. Dismiss your revision application. Does he have a case?
Item number 17, my lord, I am for the respondent, lord.
Does he have a case?
Lordship, actually, this is an lordship interim order, lordship. So if that would be lordship, challenge lordship, then entire title suit will be lordship in practice, lord.
My lord,
You are a plaintiff.
Lordship,
You are a plaintiff.
I am the plaintiff.
You saw that there is already an existing 2 feet road
Yes, sir.
and there is a possibility of another 7.5 feet.
Yes, sir.
They are trying to make it bigger.
Yes, sir.
The trial court rejected your application for which you filed an appeal.
Yes.
The appellate court says, okay, these 2 feet, you don't disturb them, But as regards 7.5 feet, there should not be any construction.
Yes.
Was it wrong?
My lord, we have filed a written statement in the plain and in the plain,
Have you extended 7.5 feet or not?
my lord, it's an existing route from they are the ancestor of the they are the relatives from Manohar Ali. Manohar Ali is the grandfather, and Manohar Ali has 3 sons, namely Manohar Ali has 3 sons, namely Muzammil.
Mr.
And-
Counsel, we are not concerned with who has so much sun. I'm only concerned is whether that road of 7.5 feet is in existence or is it only 2 feet? Answer that. That's the only issue.
Yes.
We are not concerned with how many, whoever has how many. Is there a 7.5 feet road?
Yes, ma'am. But appellant court misinterpreted the 3 golden principles and schedule.
What is your right to have it 7.5 feet? The road is where? In whose land?
Lordship, in our land.
Then?
My lord, they are also the ancestor. They are the cousin brothers of our. And from the inspection report,
Fighting amongst yourself, the cousin is gone. Now come to this.
They are trying to, Lordship, take some more land, Lordship, by constructing the Lordship larger.
no, my lord, it seems
But with a stay being granted with this order, means the entire revision is been allowed. How can you stay it? We do one thing. I'll accommodate you, but I'm not granting
My-
and
my lord,
extending the stay.
the matter may pass over for time.
Absolutely no. And I'm not satisfied with your. At the request of the learned
lord, I
counsel
have-
for the petitioner, matters stands adjourned to be listed again on 24th of June 2024. Taking into account the materials on record, this court is not inclined to extend the interim order which was passed by this court on 11/8/2000. Yes, Mr. Kat. Good. Now we get the chance to dismiss.
My lord, it is ancestral property, my lord.
So what?
From the common ancestor, my lord, both the parties, my lord.
I'm asking you a simple question. Is the 7.5 feet road in existence?
It is 8 feet in existence, my lord. As per
Is it in existence?
Yes, my lord. As per
Then
report.
how are you agreed by the order?
In the order, my lord, it is mentioned, my lord, that it is a 2 feet road.
Whatever may be.
2 feet. My lord.
What is the injunction? The opposites are further restrained from further works of extending the suit. They are from 2 feet to iman till the disposal.
There is no extending.
So there is no
Yeah.
extending, then why you agreed?
They were going to only, my lord, earth filling the road, my lord.
Don't do all these things. How are you agree with this order then? If it is already in existence. Therefore, my specific question was
Yes.
whether it is in existence or
In
not.
existence, my lord.
If it is in existence, then this injunction order does not affect you.
It is on record, my lord. The one inspection by the advocate commissioner was given by the trial court. Inspection commission, my lord, reported that 8 feet by 50 feet is there.
So if that is so, it will go as per that, as per the report to that effect. So let the status quo be maintained.
Obliged,
That's over.
obliged.
Then what is there?
Yes.
In fact, this order, that is why I was asking him only one question, whether the 7.5 feet road is in existence. If it is in existence, this order has no value.
Our case is it is 9 feet, but the report submitted by the commissioner that is 8 feet by 50 feet. In the report I have an
And that was not taken into consideration by the first appellate court.
yes, not
This is an application under Article 227 of the Constitution challenging the order dated 7/6/2023 passed in Miss Appeal number 03/2023, whereby the learned trial court, first appellate court, that is the court of the civil judge at Hailakandi, had interfered with the order dated 25/11/2022 passed by the learned Munsif number 2 Hailakandi in Miss Injunction case number 124/2021 and directed the appellants herein and restrained the appellants herein from further works of extending the suit schedule 1 part from 2 feet to 7.5 feet till the disposal of title suit number 120/2021. Full. This court have heard the learned counsel appearing on behalf of both the parties. A specific query have been raised upon, appointed query was raised upon both the counsels as to whether the 7.5 feet road is in existence or not, path is in existence or not. Mr. M.J. Kadir, the learned counsel appearing on behalf of the petitioner submits that the learned trial court, prior to rejecting the application for injunction, had issued a commission in terms with Order 39, Rule 7 of the Code, and on the basis of that, a report was submitted, dated
page 40, my lord.
Dated?
My lord, dated 8/8/2022.
8/8/2022, wherein it was categorically mentioned that the suit path is 8 feet by 50 feet. Full stop. Taking into account that there is already a suit path in existence, the learned first appellate court ought not to have the order of the learned first appellate court to restrain the appellants who are the defendants in the suit from further working of extending the scheduled suit 1 part from 2 feet to 7.5 feet was totally meaningless, inasmuch as a 8 feet path is in existence as submitted as per the report so submitted by the commissioner, so appointed. Full stop. Accordingly, this court disposes of the instant petition directing the parties to maintain status quo in respect to the suit path as it existed as on today till the disposal of it.
Petitioner is the plaintiff project. Amendment application was filed that was rejected. Petitioner wants to incorporate the name and number of a registered sale deed and
Oh, how much expenses?
yes,
Yes, how much?
That's a paragraph 3.
Only 70. Nowadays it has become very less.
Mr. State has also filed a receipt statement. That is annexed in the petition. So you would also have to do the same thing. 17 to 2 will be 1.2.
I have objection in regard to if this application is passed, allowed lordship. I have objection lordship if this application is allowed lordship.
What is that application allowed to? I don't know. What does he want to petition? He wants to amend what?
number of a sale deed that my case is that lordship 2 to 4 lordship they do not have any right title interest. It was my father's name with partner name
And their case is that lordship, my father through an unregistered deed, lordship transferred the right of the annual patta to the predecessor of the number 2 So they are the owner and they subsequently sold out the entire land to some different dependents. Some of the states already I have amended and mentioned my change. This in favor of parent number 8 was left out. That I want to record. Page 50 annexure 5 the amendment. Already pleadings is already there in the plain, but even relief portion also.
Then why do you need it?
Only specific number of the state deed and cancellation of that state deed in the prayer portion.
Let us see your plain.
Page 18, your lordship will find that is para 11A that was incorporated by way of amendment. Last paragraph. So that thereafter, lordship para 19 that the claim of the dependent number 5 to 9. So dependent number 8 was included in this para.
So you want to substitute DD or D1 or add D1?
No, lordship, I want to incorporate that is para
After here. So you want another deed of sale.
after 11.
Who is appearing for defendant number 8?
Lordship, I am
And you want,
Prayer lordship, that is 14 DI.
so you have not challenged after 11, the aforementioned here that the registered deed of sale, father of the plaintiff in favor of the father of the defendant in the
That
manner
is the
same
unregistered
territory
deed,
is
lordship.
court,
And there
manufacture and
I have
fraudulent
mentioned other deed.
and the claim of the defendant number 9 to 9 is put there on the basis of the registered certificate.
There.
So this paragraph is already there.
Lord,
Then why do you
only
need that?
To specify the deed number and specify the cancellation of that in favor of it. The unregistered deed in favor of 2 lordship. I have
And why didn't you do it then?
lordship it was that due to oversight left out that is there the petition itself. They have written that
And what is the state government stake out here?
objection filed by state government on the written statement.
No, what did is there any allegation against the state bank?
Their case is that lordship, my father did not use the annual patta, so the predecessor of the dependent number 2 to 4 annual patta was to and thereafter that was made merely in favor of. That is the stand taken by the government in written statement, page 24.
So you are challenging the in issuance of annual your rejection of yeah. Why you are filing the suit against the state of Assam?
Lordship, the order was already passed by the officer, but the government in favor of the 2 to 4, making that Niyati Patta in favor of them, but without there being any order of issuing annual patta in favor of the predecessor of the parent.
Is it required?
Lordship, if I am an annual patta holder, my annual patta position to be transferred to some other person.
Is it required?
If
One
I
can
am
be.
I
Anyways, I am not in second appeal. Why should I do it? Isn't it?
only
But
lordship,
I have taken up a similar matter out here. When an annual patta is issued and the annual patta is later on, it can be cancelled. It may be. A cancellation may be legal, illegal, that is another aspect. But issuing a patta is a settlement made in their favor.
no, our case is that but my annual patta was never cancelled. Now they are taking stand that my father did not knew that was cancelled, so Niyati Patta was
But you amended your plaint earlier. Again, you are asking for that.
only dependent number 8 remains. That's it. But pleadings already included dependent number 8 also.
Hello? How much is the land?
5 big already they took out to different parts. That's not pretty.
5 bighas.
But the state stand is that it was mutated in the to the process called Waris Namdar.
Hmm. Where is the
They
land?
had stopped paying the annual Bhatta revenue.
Hmm.
So, so the persons who were paying it and were in possession were their names were mutated. Obviously, there must have been a proper application at that time.
100%.
And from that date, 12 years had passed. 12 years had passed. Now it is 14 years. Actually. So adverse possession protection, they won't be getting. The people who are in possession, they will be getting.
Now, you admittedly did not challenge the deed of sale earlier. Or did you say challenge the deed of sale?
After the death statement, we amended our.
Understood. Did you challenge the deed of sale?
All the deeds were checked.
Then why do you want it?
Only 8 deed of the respondent dependent number 8 remains.
So you did not challenge it.
Not.
So this challenge has to be, we cannot bring the principle of relation back. With the amendment, it goes back to that position of filing the suit. Now, you came to know on the basis of the written statement filed. When was the written statement filed?
No, Lordship, this
Lordship.
amendment is after a cross, Lordship, cross of PW, one of the PW.
This came to light.
Yes.
Which is at the stage cross exam. That is there in the impugned order. Everything is very clearly explained.
What does it say?
Why it was rejected. Because just before the cross examination, they brought in all these things just to delay me. Maybe they are trying to cloud something.
Oh,
Lordship, there is a judgment.
heard
Case
the learned
19,
counsel for
Lordship,
the court
already
of
said
parties
that the
stated
claim of
therein
the dependent
one
number
the
5
court
to
to
9.
the plaintiff came and obtained one. So you were asked a question. Must have been asked a question during cross-examination. No, I'm not asking that, Mr. Sharma. I'm only putting that question specific to that. That whether the plaintiff must have come to learn about this deed of sale when you filed your written statement.
But what if they have not mentioned any deed number in the written statement?
How did you come to know?
They only stated in the written statement that dependent number 2 to 4 subsequently transferred or acquired then to the other.
Then how did you know about the deed number?
We acquired for the sub-registry of.
When?
That already it is.
You must have stated in your petition.
No, that was not mentioned in the petition. I have
Then?
checked.
How do I help you?
That it was mentioned that this matter of amendment could not be brought earlier as the engaged advocate for the plaintiff could not detect it. So that is the line taken by the trial court, and on these grounds only the amendment was allowed, rejected. Already there is a pleading that if any deed was made in favor of dependent number 5 to 8, those to be cancelled. and already it was also, their vendor deed was already paid for cancel. So lordship, if unregistered deed goes, then this tenant number 8 may not have been.
Or for that matter, your relief as regards the state is allowed. All other consequences
Everything
become
is good.
useless.
So lordship, this proposed amendment, not lordship, the defendant not suffered much. Only the for specific.
But is the proposed amendment necessary for adjudication?
As lordship, already all the.
It's already there.
One question will remain that lordship, we have not paid for cancellation of the registered sale.
Understood, but if the sale deed already is gone, means if the land reverts back to you, then all sale made becomes illegal.
Registered sale will remain in future the state. So already all the registered sale deeds were mentioned in the paper. Only this is remain as soon as at the stage of cross of PW. Page 9 or dependent number.
We are paying for defend number 8. Okay. We allow it with cost.
Are we paying for defend number?
We allow it with cost of 15,000 upon to be paid to the defendant. This is an application under Article 7 of the Constitution challenging the order date 31/8/2023 passed by the Court of the Civil Judge Junior Division of Salmar in title suit number 198 of 2021, whereby the application filed under Order 6/17 of the Court seeking a further amendment to the written statement to the claim was rejected. This court had perused the application under Order 6/17 read with Section 151 filed by the petitioner before the learned trial court. This court have also perused the amended claim. On a conjoint reading of the amended claim along with the application under Order 6/17 to 5, it transpires that the said amendment so sought for amounts to amplification of the pleadings which were already there on record. As regards the relief which was sought for, which was sought to be inserted by way of the amendment, the relief is specific, taking into account that on the earlier occasion, the plaintiffs have sought for cancellation of all deeds of sale against the defendant numbers 5 to 8, executed by the defendant number 2 to 4. Now, by way of this amendment, the registered deed of sale which was executed in favor of the defendant number 8 was specifically sought for cancellation. In the opinion of this court, if these amendments are not permitted, it would result in ambiguity at a later stage and unnecessary complications. Accordingly, this court, for the purpose of deciding the real question in controversy, permits the said amendment as sought for by the application being petition number 743/2023 filed on 17/3/2023. This court also takes note of that if this amendment is allowed, the suit again would revert back to the stage of filing of additional written statement, framing of additional issues if need be. Inasmuch as presently the suit is at the stage of cross-examination of the plaintiff witness. In that process, the defendants, more particularly the defendant numbers 5 to 8, you are jointly, you have filed a joint written statement.
Yes.
May have to would have to require to file an additional written statement. In addition to that, this court also takes note of that the appearance of the parties, also note of the cost which would be involved again to revert back to the stage presently the suit is. In fact, on the last occasion, this court had asked the counsel representing the defendant numbers 5 to 8 to file an affidavit as regards the cost which would be incurred.
It's filed by reference number 10.
And in that regard, an affidavit has been filed. In paragraph number 3 of the said affidavit, there has been details mentioned as regards the revision, instant revision application. But as regards the suit, what has been mentioned is an amount of rupees 10,000 on account of the hearing on the petition for amendment of the plain and an additional amount of rupees 10,000 for filing the additional written statement. However, there is no mention as to what further additional expenses would have to be incurred. As regards the appearance fees of the counsels. Taking into account that the amendment has been allowed, by this court herein above, and it would result in filing of an additional written statement as well as the other expenses on account of counsel fees. This court reasonably is of the opinion that an amount of rupees 20,000 would recompense the defendant numbers 5 to 8. Accordingly, this court therefore permits the amendment to the plain on the basis of the petition number 743/2023, subject to deposit of an amount of rupees 20,000 before the learned trial court. This court further fixes the matter before the learned trial court on vacates the earlier order of stay of the suit and directs the appearance of the parties on 19th of June 2024 before the learned trial court, and on which date the amended plaint would be shall be filed. An amended plaint is required to be filed, incorporating the amendments in terms with the petition number 743/2023, and also the amount of rupees 20,000 be deposited, which shall be a condition precedent for acceptance of the amended plaint. It is further observed that if on 19/6/2024 the said amended plaint and the amount is not deposited, the consequences in terms with order 6 rule 18 shall follow. The petition, the respondent, defendant numbers 5 to 8 shall be at liberty to file an application before the learned trial court for release of the said amount, and the learned trial court shall pass appropriate orders thereof. With the above, the instant petition stands exposed.
Defendant number 213.
Huh?
Defendant number 213.
All
Joint
right.
written statement.
2 to 13.
Amount.
The defendant number 8. Defendant number 8 actually with the defendant number 2 to 8. 2 to 13.
13.
2, 5 to 8.
Yeah. Got 50,000.
Huh?
50,000.
No. 20.
Okay.
Yes.
Lordship, I'm appearing on behalf of Mr. A. Kakoti.
Go.
Mr. A. Kakoti is not present today, so I request the honorable court to adjourn the matter for today.
I don't adjourn. You want, I can adjourn it for 2 years also, but I'll vacate the state. That I can.
Lordship, Mr. A. Kakoti, his father-in-law health condition is not good.
Huh?
Mr. A. Kakoti, his father-in-law health condition is not good, so he's at the hospital.
And help it.
Medical ground.
We'll have it next week.
Yes,
I
Lordship.
hope he doesn't. Let's fix it on 3/6.
Okay.
Interim shall continue only till then.
Lordship, even I request the court to extend the stay order
Till 3/6.
till 6.
At the request of the learned counsel for the petition, matter stands adjourned to be listed again on 3/6/2024. The interim order passed earlier shall continue only till then. Yes,
Sorry, my lord. Last
Mr.
submission I could not
K.
present that, but
yes, why you are not appearing in the
Lordship,
matter when the
in
matter is called?
last occasion I was in another court while moving. In the meantime, the item.
Yes, what are you challenging?
Lordship,
Actually,
the matter may pass over for the time being.
Why?
Lordship. After some time, my senior law school
No,
is
no.
another court.
First, let me be satisfied with him. If I am not satisfied, I'll dismiss it. Then your senior's presence is not required. Yes, what are you challenging?
my lord, actually challenging, my lord, the petitioners before your lordship, they are neither relatives nor lordship have anything, lordship. In spite of that, lordship, they are implicated as respondent, lordship, in the domestic violence case, lordship.
So,
So,
how this court will find out whether they are related or not?
lordship, I have my categorical statement, lordship, of
No,
that.
no. For categorical statement, these elections are ending. After the elections, I may be given some election tribunal election cases. Then we may have a witness box. Then should they take up your matter then?
Lordship. For that
Absolutely. Let
petition,
that be decided by those courts.
but lordship, it's an harassment for me, lordship,
So
because
what?
I am nowhere related with him.
Whether you are related or not, how do I know?
And apart from that, lordship, in the domestic violence case, lordship, the As per section 2Q Lordship, respondent means any adult male person who is or has been in a domestic relationship. We have a no domestic relationship, Lordship. And in the petition, Lordship, only allegation. Lordship, only allegation in that respect, Lordship, the respondent, Lordship, page 43, Lordship,
Respond number 2 and 3.
2, 3, and 4, Lordship.
Where's 4?
That is,
2, 3 and 4. How are they
sorry,
related?
respondent 2, 3,
2
and-
is who? Aziz Dur Bolbhuiya
Lordship, Masum Ahmed
and
Bolbhuiya.
Mirzajur Rahman.
Lordship, father names
Idris
is not
Ali
related, Lordship.
Laskar.
If necessary, I will produce
Where is the
paper.
allegation? Where is the allegation?
Allegation is page 43, Lordship.
Yeah. That about 3 months ago on Imran, a quarrel took place between the AP.
Lordship, last line,
Number
Lordship.
1, thereafter the AP Chalo, we do one thing.
Lordship.
This is a case before under domestic violence.
Lordship. And there is no prayer against us, Lordship.
Hello. We asked the magistrate to convert it into a 66C and 66D of the Information Technology Act matter.
Regarding our relation.
No, for whatever the allegation is, and then to proceed.
Yep.
And we do it today itself, because why today? From 1/7, the new act is coming. And there, the provision is more stringent. So now let us do it with 66C and 66D.
Lordship, with all fairness.
Yes, better.
May I pray, Lordship? I may be allowed to throw the petition to
Yeah,
file my.
better.
Lordship, because
Yeah.
I have another judgments are there, some judgments are there.
But with this allegation, I'm not concerned. You may not be related out there, but you have a serious allegation that you beat her up and then made obscene videos. With this is a very serious
Lordship,
allegation.
I may be allowed to truth and I will
Yeah.
file my WHR.
At the request of the learned counsel for the petitioner, the matter stands, Mr. K. A. Majumdar, learned counsel appearing on behalf of the petitioner, submits that maybe he has instructions to withdraw the instant petition. Accordingly, the petition stands closed on withdrawal. Full stop. The interim order dated 12/2/2024 stands vacated. Full stop. Taking into account that the parties are duly represented, the parties are directed to appear before the learned Chief Judicial Magistrate Hailakandi in DV case number 139/2023. You were appearing earlier.
No, Lordship, only respondent number 1 appeared.
Okay.
Will appear, Lordship, and will
Shall appear before shall appear before the learned Chief Judicial Magistrate Hailakandi on when? On 21st of June 2000. Either to how is it a person appears out there in the DV case through counsel or the person?
No, Lordship, the counsel.
Counsel, no?
It was filed by the counsel. And then so yeah, the interim order stands vacated, and this court fixes the matter before the learned court of the Chief Judicial Magistrate Hailakandi on 19th of June 2024, and this order shall constitute due notice upon all the respondents, all the parties present before this court. Yes.
May I praise the Lord?
Hmm.
My Lord, the petitioner is the plaintiff. It is good. He filed a suit for partition of the property,
Suit for?
suit for partition.
Okay.
The suit was declared by the courts below, trial court. And the defendant prepared an appeal before the lower appellate court. And the both parties appeared and arguments were heard.
Oh, this matter, I've seen it. No reasons, nothing.
Yeah.
Remember, on that day, on the ground that Mr. Kolita was not there, they took adjournment.
No, there are
Oh,
two
there's another matter similar.
similar.
Yeah.
Because
What type of
the-
order is this, Mr. Kolita? Is this the order at page 6 and Annexure 6?
66.
Yes, what type of order? If he wants to remand or do whatever I feel like, this is a case of hence in exercise of the powers conferred under remand, this court is posted for recording and nobody filed an application under Order 41 Rule 27. There's another matter, no?
Yeah,
Similar matter.
Similar.
Same order
same one.
by the same judge.
But the same says because
100% because the writing seems to be same. Exactly the same language.
because two appeals were filed against the same thing.
And what evidence? Why the evidence is required? Nothing is.
Actually, my lord, we have challenged that the power of attorney, because the plaintiff has not signed. It was the power of attorney holder, he filed the suit, he filed Hokalatnama, everything. We challenged that. That's why after hearing the argument, my lord, the court is of the opinion that let the plaintiff be examined. That is the reason, and order under Order 27.
But how do you infer that opinion, the court's opinion,
Yes, my lord,
unless it is written anywhere?
I am coming to that. My lord, Order 27 B, my lord, appellate court has the power, number one. Number two, my lord, the recent Supreme Court says that if for the ends of justice and other things, my lord, the court can pass the order without filing the application. Although this suit was filed, this order was passed on filing of the application. My lord, there is a last judgment, my lord, I could trace out.
Yes, tell me
Order-
what is that?
Order 22, 7 SCC 427, my lord. Here, my lord says, 22-7 SCC 247. Sanjay Kumar Singh, my lord, Doctor, State of Jharkhand.
Single. Sanjay Kumar single.
Sanjay Kumar Singh, my lord,
Sing,
State of Jharkhand.
sing or single?
Singh, my lord, here. In the book, it is Singh. Here, last line, my lord. Even one of the circumstances in which the production of additional evidence under 41 Rule 27 CPC by the appellate court is to be considered is whether or not the appellate court requires the additional evidence so as to enable it to pronounce
Paragraph.
That is paragraph 7, my lord.
It's true that the
Paragraph 7,
general
last line,
rule
my
that
lord.
the appellate court should not travel outside the records of the lower court and cannot take any evidence in it. However, as an exception, enables the appellate to take additional evidence except that may be also be put may permit that if the petition is found found to exist and the partition Then this is remains the same, but how without application?
My lord, because, my lord, we argued before the court, my lord, that the power of attorney holder, that power of attorney is a false document, my lord. It was neither registered, nothing. Plaintiff has not filed anything. Earlier to that, my lord, this particular power of attorney holder, he filed a suit against this particular defendant, my lord. Those suits were dismissed. Thereafter, my lord, subsequently filed this suit. So we have fully challenged that this power of attorney is false and power of attorney holder has no right or authority under the law to give evidence on behalf of the plaintiff. After considering all these facts, my lord, the trial court, appellate court is of the opinion that the plaintiff is required to be examined. That's why this order was passed. And other order 27, order 41, rule 27B, my lord, the court has the power for pronouncing the judgment. That was supported by the Supreme Court, my lord. That is my submission.
No, where does it say that without an application it can be done?
Here, my lord, the B says, my lord, no application is required. B says, order 27, order 41, rule 27B, my lord. The appellate court requires any documents to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. Because the court is of the opinion that the power of attorney is a false document, my lord. From above, my lord, the parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. But if B, the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. Because they will never file any documents that the additional evidence is required. And apart from this, my lord, the present, during the pendency of this case, my lord, the power of attorney holder is also died on 6/3. On 6/3, my lord, this power of attorney holder, he died. Yeah. So, plaintiff is not there. Power of attorney also, my lord, gone because he died.
And you are paying for who?
Initially, we appeared for power of attorney holder.
Now?
This
Now we file a separate
case is also filed by power of attorney holder, my lord.
No, no. Thereafter, after his death, we file a separate collectum of the plaintiff.
The
Petition.
plaintiff is appearing now.
Yes.
Where is it?
We have filed on 9/5/2004. Okay, 9/5/2020.
L. Chakraborty. L. Chakraborty.
See, so
C. Chakraborty. Whatever may be. How can the court pass an order like this?
After hearing the argument, my lord, when the judgment is fixed, my lord, the court is of the opinion that the plaintiff is required to be examined.
Understood, but you are saying that.
Yes.
Where is it mentioned that the plaintiff is required to be examined? In that order.
Order, in order, my lord.
So you, the appellant knows what the judge thinks. This is a fit case for transfer.
Respondent number 1, plaintiff number was necessary being additional evidence to decide the appeal.
Huh?
plaintiff number 1 is changed, matter. Evidence of the plaintiff number 1 is necessary. It was given, my lord.
No, we set aside this order. Let the court decide that and pass a reasoned order why it is required. You cannot say that to that while hearing, yes, he may very well record that these submissions are being made and on the basis of which it has now happened. And now too, it would become much easier. Power of attorney is dead. He has to appear. Then call him. Earlier it was difficult. Now you have it.
Reason is not given, my lord. That is correct.
Now, this is an application under Article 2 to 7 of the Constitution challenging the order dated 22/12/2023 passed in title appeal number 5/2016. Whereby the learned first appellate court of the additional district judge number 1 Kamrup Metro at Guwahati had passed an order for evidence of respondent number 1 / the plaintiff to be taken in terms with order 41 rule 27 of the code. The senior counsel, Mr. A.C. Sharma, the learned senior counsel appearing on behalf of the petitioner submits that the learned first appellate court order is bereft of any reasons. And as such, the said order requires to be interfered with, inasmuch as there is no mention why there is a necessity of the respondent number 1 / the plaintiff's evidence, and what evidence is also required. On the other hand, Mr. P.K. Kultan, the learned senior counsel appearing on behalf of the respondents herein who are the appellants in the said appeal submitted that the partition suit was filed through a power of attorney agent. The entire proceedings in the trial court was done through the trial power of attorney agent, and the plaintiff never appeared. The counsel further submitted that there were, during the appellate stage, this aspect of the matter was duly agitated, and it is under such circumstances the court, the first appellate court, in its wisdom, thought it required passed the order for evidence of the respondent number 1 / plaintiff. Having heard the learned counsel for the party, it is the opinion of this court that the general principle is that the appellate court should not travel outside the records of the lower court and cannot take any evidence in appeal However, the exception is the provision of Order 41, Rule 27 of the Court, which enables the appellate court to take additional evidence in exceptional circumstances. The circumstances have been duly enumerated in Order 27, Order 41, Rule 27, 1 clause enumerated in subclauses A, comma, AA and B of subclause 1 of Order 41, Rule 27. For exercising the said power in exceptional circumstances, it is also the requirement of law that the first appellate court has to assign reasons, and merely stating that the evidence of respondent number 1 oblique the plaintiff number 1 would be necessary would not suffice. The said order, impugned order, does not mention as to under what circumstances the court wants to exercise the powers under Order 41, Rule 27 of the Code. That too, when there is no application being filed either by the parties. Accordingly, this court interferes with the order dated 22/12/2023. However, this court makes it clear that the orders passed herein shall not preclude the learned First Appellate Court to exercise the powers under Order 41, Rule 27 of the Code in accordance with the prescription contained in the said provision. The order dated 7/2/2024 passed by this court, whereby the title appeal number 5/2016 was stayed, is hereby vacated, and the parties are directed to appear before the learned First Appellate Court, that is the Court of the Additional District Judge number 1, Kamrup Metro at Guwahati, on
29 seconds. Next day. Actually, today is fixed, my lord.
okay, on 18th of June.
Withdraw.
Yes, what are you challenging here?
My lord, my petition is this, my lord. I filed a petition under Order 41, Rule 27 for producing additional documentary evidence in the trial stage. So, my lord, your lordship, actually trial court judgment was passed on 22/12/2020, and I received the connected Jawabandi copy in 22, my lord. So I want to produce that Jawabandi copy or to agitate certain point. But the court says that after due diligence, we have no due diligence to produce at the time of trial. And it is also contended that the petitioner was not refused to produce that document by the trial court. From a humble submission before your lordship, I did not have the copy.
My lord,
The question of due diligence will not.
my lord, my LTD is of 1955. They have only used the word fraud in their defense without stating.
All understood. How do you take care of Ibrahimuddin versus Union of India? Wherein it says that you are to take into consideration that application at the time of disposal of the appeal. How did the court decide this application prior to that?
That thing is there, Lordship.
So that is the
But-
only thing. And I think I had admitted, I had issued notice in this matter earlier.
No, Lord. At the time of hearing, it should be said.
The only thing is that paragraph 51 of the judgment, at what time you are to consider the application under. So we set aside this area, however, without being, without the fact that this court has set aside, the court shall be at liberty to decide the application at the time of final disposal of the appeal.
Along with the that is
That's it. That's the law.
otherwise no due diligence and all.
Understood, but you see, I don't. That's the law which has
Yes,
been laid
yes.
down by the Supreme Court. I
That's
can't help it. Now, heard Mr. M.A. Sheikh, the learned counsel, appearing on behalf of the petitioner, and Mr. J. Dekka, the learned counsel, appearing on behalf of the respondent. The present application under Article 227 of the Constitution is filed challenging an order dated 18/3/2023 passed in title appeal number 3/2021, whereby the learned trial court, first appellate court, that is the court of the civil judge Nolbari, had rejected the application under Order 41 Rule 27 filed by the appellants for adducing additional evidence. This court is of the this court, taking into account the judgment of the Supreme Court reported in the judgment of the Supreme Court in the case of Ibrahimuddin versus Union of India. Union of India versus Ibrahim.
Union of India versus
Ibrahimuddin
and
reported in 2012, 8 SSC 148.
Yeah.
Is of the opinion that the said order is in conflict with the express stipulations contained in the said judgment, wherein it has been categorically mentioned that the application under Order 41 Rule 27 of the court has to be taken into consideration at the time of writing at the time of
final hearing. Okay.
at the time of final hearing of the appeal, and to consider as to whether the said additional evidence would be required for passing the said judgment. So, taking into account the above, and in the facts of the instant case, as the said application was disposed even prior to the final hearing of the appeal, this court interferes with the order dated 18/3/2023, passed by the learned first appellate court, Worcester. This court, by an order dated 21/4/2023, had stayed the further proceedings of title appeal number 3/2021. The said stay order stands vacated and the parties are directed to appear before the learned first appellate court on 19th of June 2024. The first appellate court shall consider, in view of the law laid down by the Supreme Court in the above case, in the above referred case, in the case of Ibrahimuddin Supra
Union of India. Union of India is there.
versus Ibrahimuddin Supra, shall consider the said application at the time of final hearing of the appeal and pass such orders as within the purview of in terms with the stipulations contained in the said judgment. It is further observed and directed. It is further observed that the learned first appellate court shall not be influenced by the order passed on 18/3/2023, which have been impugned in the instant proceedings, as well as the order passed herein while deciding the application under Order 41 Rule 27 or the appeal being titled Appeal number 3 of the 2020
Much all right.
with the above the instant petition.
Obliged.
I could have done it yesterday, no? Yesterday I got really tired after delivering that long judgment.
Obliged, Lord.
Both the matters were critical. Both the matters were critical.
Yeah.
Point
yeah.
three.
No, the second matter has a very
Yes, yes.
lot of ramifications in respect to every person will have a ramification. Means every day you are getting a crank call out there wherein you are being asked what is your number, what is and all these things. Every day you are getting out there.
It is increasing day by day, my lord. Though the internet banking etc. is very necessary, but it is complicated.
No, here
We are
in that
facing
case,
this-
yesterday's case, this person concerned, he has a normal mobile. He never applied for internet banking. He never used UPI in his life. Nothing.
Yes.
Somebody took his just debit card details and did everything.
Vulnerable people are always there, Lord, in ATM, asking for help.
Obliged.
May I please, your Lordship. Lordship, in the CRPIO, we have filed an this case. That is IS civil number 1392/2024 for modification of the interim order that has been passed by this honorable board. The interim order,
Wait. Let him satisfy this court. That this
My
court, this order requires to be set aside.
My lord, the advocate of record. He is in Canada, my lord. It's family problem, my.
Who?
S. Dasgupta.
Huh?
S. Dasgupta.
So what?
He is in leave, my lord.
So what?
So
We will vacate that order.
at least 2 weeks time maybe.
No.
My lord. 2 weeks time maybe.
No. I'm not concerned. You knew this matter was fixed on. The matter came up on 14/5.
Yes,
None
yes,
has
yes.
appeared on behalf of AI. For the ends of justice, this court has the
Yes,
matter there. We are not concerned where the counsel is. The counsel is not there. Did you file the wakalatnama? Did you file the wakalatnama?
2 weeks time maybe given.
I'm asking you, did you file the
No,
wakalatnama?
no, my lord.
Okay, none
2 weeks
appears
time
on
might be
behalf
given.
of the
I will fight
petitioner.
my Uttalatma, my lord.
Sorry. Nothing doing.
2 weeks time at least.
I'm vacating the stay. And this order stay was not there. There is no stay.
no, Lordship, on the last occasion, it was
I didn't extend it.
extended.
So the proceedings can continue. And the petitioner shall continue to pay the monthly maintenance. Have you got the money?
Yes, Lord. That monthly maintenance was paid. The 50% which has been directed, that has not been paid.
This is as regards the retirement, no?
Yes,
Yes,
Lord.
retirement.
Tomorrow he is retiring.
Hmm?
Tomorrow he
That is why
retiring.
we fixed the matter today. You want a stay. There is a stay order.
Yes, Lordship. There is a stay order on the order passed by the learned trial court. That is order dated 30/10/2023.
Maintenance shall be as per the agreement. What is that order passed for? Till the
Lordship,
petitioner
that is
cease
the
to be the
in view-
wife of the present heir, she shall continue to avail the medical facility as per the heir. Therefore, we do not pass any order in that regard. The matter monthly maintenance of 30,000 shall be paid by the present petitioner. Respondent to the petitioner as per the agreement shall be considered as per law after disbursement of 50% of the retirement benefit to the present petitioner. Who is the petitioner?
Lordship, here the petitioner is the husband, Pritam Syam. He is an employee of ONGC.
Hmm.
And the direction was given to because there is no scheme for pension and it is given in one time. So the learned trial court has directed that the 50% should be paid to the wife. That was the direction in Annexure 1 of my IA. That is order dated 30/10/2023. Divorce proceeding is pending.
No, we do one thing. You are entitled to 50%,
Yes, Lord.
and he is entitled to
The other
50%.
50.
Let that 50% be released to him,
Yes, Lord.
but remaining 50% be kept with the
ONGCL.
ONGC.
That is the modification we made.
I think that is a better option. That will be safe.
And he's paying the monthly maintenance. So his 50% is kept with ONGCL. It will be
The ONGC shall not. Who is paying for the ONGC? Is the party here?
no, Lord. ONGC is not a party. He is the employer, so they did not make him party there. ONGC was not made party in either of the proceedings.
Then how do I direct?
Lordship, because they are the employer, Lordship can direct.
How?
Because earlier also, I have somewhere I have seen one judgment in this regard that the employer can be directed to retain. They are to pay, deduct the maintenance, because ONGC is deducting the maintenance 30%. They are deducting, even though they are not a party. They are deducting and paying it to the wife. That is to me.
The 30,000.
Yes, Lordship. So they can do it. They will have to only hold the.
No.
And we will file a misapplication in the meantime to.
But one thing here, the court had passed the direction for payment of 50%.
Yes, Lordship.
That is too much.
Lordship.
You see, as an interim, when the matter is yet to be decided, the court should not have passed it. The court should not have passed that 50%. So court should have directed till the disposal of that,
Retaining.
retain that 50%.
I
That
agree.
should have been done.
Yes, Lord. Because unless it is decided.
We interfere with that order and say that the court, that the trial courts, that the instead of directing the ONGC to pay the amount to you, they shall retain it till the disposal of the proceeding,
Yes,
or such order that may be passed by the family court during that.
Yes, Lord.
I think that is a better option.
Yes.
What do you say?
I hope.
None appears. None appears for the petitioner.
My lord, I appeared on the inspection of the council.
So you have
at
no
least
authority.
2 weeks time maybe given if it I.
No, what will happen tomorrow? He is going to retire. And if he gets the entire money,
Lordship, in practice in ONGC is that they used to give it in the day of the retirement. So if that is done, that will serve the ends of justice. But only right is that.
If I am not mistaken to.
and your entire prayer is that you are not harmed by anything. Your 50% will remain intact with ONGC, which shall be further decided at a later point of time.
My lord, if I am not mistaken to apply the honorable court, let this matter be kept pending and stay order may kept, and this court may direct that not to release any money, but that will start. So the next time this court will hear
Not to release any money to anywhere, any of the parties.
any of the party for the ends of the. After hearing the party, this court will decide.
I cannot. This interlocutory application has been filed by the respondent. To the accompanying revision application. Seeking a direction for vacation, modification, or alteration of the order dated 12/12/2024 passed by this court, and with a further direction to the ONGCL authorities not to disburse 50% of the retirement benefits either to the petitioner husband or the respondent wife till the disposal of the accompanying revision petition. The learned counsel appearing on behalf of the applicant submitted that the opposite party herein, who is the petitioner in the accompanying revision petition, is going to retire tomorrow, isn't it?
Yes, Lord.
That is on 31st of May 2024.
Day after tomorrow. Today is 29th, so day after tomorrow.
Is going to retire on 31st of May 2024. And it is the practice followed in the ONGCL that on the date of the retirement, the said amount, that the entire pensionary benefits
Yes.
are given on a lump sum to the employee. He therefore submits that if some order is not passed today, thereby directing the ONGCL to withhold to the amount of 50% of the retirement benefits, it would be very difficult at a later stage for the respondent, for the applicant to get the said amount.
Yes.
On the other hand, Mr. I.A. Talukdar, the learned counsel, appearing on instructions submitted that the matter be adjourned for a period of 2 weeks. Until that date, the ONGC may be directed not to release any retirement benefits till to either the petitioner or the respondent. He submits that the leading counsel in the matter, Mr. S. Dasgupta, is out of town.
Out of India.
Out of India is also out of town.
Yes.
Is out of town. And as such, the petitioner would be prejudiced if the matter is finally disposed of. Taking into account the above, this court, therefore, taking into account that a decision would be required to be made in respect to the legality and validity of the order dated 30/10/2023, passed in title suit M, case number 24/2018. And there is a imminent need of a certain interim directions to be also passed, else the applicant would also be severely prejudiced. This court fixes this matter again on 24th of June 2024. Till then, the ONGCL, no, the ONGCL is directed not to release any retirement benefits to either the petitioner or the respondent till further orders of this court.
If it is not
A copy of the order be served upon the respective to the concerned ONGCL authority for due compliance.
My lord, copy of the IA and affidavit numbers can be passed up.
I stands disposed. What are you going to do?
Affidavit copy may be.
Affidavit. You say that you have not filed wakalatnama. He will give to whom?
My lord, I filed wakalatnama.
You have filed.
I will file.
You will file. Then he will serve. It will hold in view of the order, it means in view of the order passed in this matter on 20.
45. Please, sir.
the impugned order is at page 36 as well as that page 41. Order whereby the cross-examination of PWs has been dispensed.
May I please? Lordship, I am appearing for respondent number 1. Lordship, FCC will file on 22/2019, Lord. During pendency of the court, Lordship, during pendency of the case, Lordship, respondent of this case, Lordship, petitioner of the FCCB, he appeared 41 days, but FC Civil respondent, she appeared only 9 days or 10 days.
Where?
FC Civil, in case of FC Civil, Lord. During pendency 19 Lordship. Till date, she appeared 9 or 10 days, Lord. Also, petitioner Lordship paid rupees 20,000 as a litigation fee, Lord. So, Lordship, my humble submission, Lordship, no more delay, Lordship. Till 19, Lordship. 6 year.
Who is 90?
2019, Lord. From the
Oh, divorce.
Yes.
Where is it? In the
Lordship, kindly see
family court?
family court. All documents of family court, Lord.
Not necessary. But it is in the family court.
Yes, Lord.
He wants to do what? Cross-examine.
Cross-examine. So on the next day, I will cross-examine this one.
I will mean?
I will mention the petitioner for your law. They are
Those are who? Who are those? The mother-in-law.
no lordship. The PW1 is the petitioner himself, that is the husband, and PW2 and 3 are 2 of his friends. As per the evidence filed by them.
No. Respondent along with her son and her family members. That is the mother and the brothers of the petitioner.
It's not lordship. Mother and brother of the respondent hearing of the petition hearing, they are not as they have not filed their evidence in chief before the learned family court.
But didn't you tell me on the last occasion?
No. I told on last occasion lordship that the brother-in-law as well as the mother-in-law of the petitioner before his honorable court are supporting the case of the petitioner hearing, and he is with the family members of the respondent family, Lord, in the same house. And
Lordship, in
and
the
from-
same house,
from the
but my possession, Lord. This is my possession,
yes,
not
lordship.
not their possession.
I am
Both are
standing-
divided. She are in the land, Lordship. Lordship, she is stay in my possession, Lord.
admitted, lordship.
Only because my son is
lordship,
with her, Lordship.
an extra ray is the plain lordship wherein lordship.
You want a divorce from her. Isn't it?
Lordship.
And she's staying with you.
Yes, Lord.
And the mother-in-law, your mother?
My mother with me, Lord.
In the
Not,
same
not
house.
with her, Lord.
In the same house.
Not with her, Lordship. In the same place, Lordship, not same house, Lordship. House is separate, Lord. My mother with me, Lord.
Mother is with you.
Yes, Lord.
Your brother is with you.
Brother is separate, Lord.
And she stays in
She
the
says it's another house, Lord.
or in the same land
Same
compound.
compound, Lord.
From the
Now she wants to cross-examine which PW?
all 1, 2, 3.
One. No further adjourn.
If this honorable court pleases to allow my decision, lordship, I will cross-examine on the next day. My learned friend is stating that the case has been delayed. Lordship, we are we also want a speedy disposal of the case. In that case, if this was then outer limit may be fixed or fixed. During that time, the case may be disposed of by the client. I have no objection to that extent. I am also want to disposal of the trial court.
Delay lordship is since 19 lordship. Case is pending before the learned below court lordship. 6 years running lordship. She only appeared lordship 10 days. Out of pendency of the court.
You do one thing. You pay her some money
Lordship,
so that she can engage
I
a
was
lawyer.
pay rupees 20,000 litigation fee, lordship.
No,
I
no,
have no income.
litigation fee. No. You need a rich lawyer like you. So you pay some more money so that she can engage a lawyer who will appear every day. Will dispense with her appearance. She
Lordship,
can work out there in the household. You appear every day in the family.
Lordship, she engaged in lawyer learned below court. Lordship was the respondent of this. Respondent not engaged lawyer. Because no income.
This is an application under Article 27 of the Constitution, challenging the orders dated 2/3/2024 as well as 10/4/2024. Whereby the learned, by the order dated 2/3/2024, the evidence of the plaintiff witnesses were closed on account of the petitioner herein, who is the respondent, did not cross-examine the plaintiff witnesses. Subsequent thereto, the petitioner herein had filed an application for recalling of the order dated 2/3/2024, which was rejected by the order dated 10/4/2024. It is under such circumstances the petitioner is before this court. This court have heard Mr. So appearing on behalf of the petitioner, as well as Mr. So, the learned counsel appearing on behalf of the counsel appearing on behalf of the petitioner had submitted that on account of the petitioner suffering from ailment and beyond the control, the petitioner could not appear before the learned trial court on 2/3/2024. And immediately thereupon, when the petitioner appeared by filing the application, which was registered as petition number 820/2024. However, the same was rejected on the ground that certain medical documents were not placed. He submits that the matter being in the family court, where the legal where representation through advocates is otherwise not permissible in view of Section 13 of the Family Courts Act 1984. Interest of justice. For the interest of justice, the petitioner should be given and ought to be given an opportunity, ought to have been given an opportunity by the learned trial court without being so technical. On the other hand, the learned counsel appearing on behalf of the respondent submitted that the respondent have appeared before the family court on 41 occasions since 2019, whereas the petitioner had appeared only on 10 occasions. So it is the petitioner have been delaying the disposal of the said proceedings, which have been pending for the last 5 years. He therefore submitted that the learned trial court was not, there is no error in the orders dated 2/3/2024 as well as the order dated 10/4/2024. The order dated 2/3/2024 as well as the order dated 10/4/2024. I've heard the learned counsel appearing on behalf of the parties and have taken into account their respective submissions. From the materials on record, it reveals that the petitioner herein is a diabetic patient and it has also renal ailments. It is further seen that on 2/3/2024, the petitioner could not appear on the ground that the petitioner had developed chest pain on 1/3/2024. However, the same explanation was not accepted by the learned trial court on the ground that medical evidence had not been placed. In the instant proceeding, however, this court duly takes note of the medical evidence which have been placed and is of the opinion that the petitioner ought to be granted another chance, else serious prejudice would be caused. Accordingly, this court therefore interferes with the order dated 2/3/2024 as well as the order dated 10/4/2024. Thereby directing the learned trial court to permit one additional chance to the petitioner to cross-examine the plaintiff witness. This court, by an order dated 15/5/2024, had stayed the further proceedings of FC case, civil case number 138/2019. The said stay order stands vacated, and the parties are directed to appear before that court on
25th June, Lord.
26th of June.
25 June, cases fixed before
25 June. The parties are directed to appear before the learned trial court, before the learned court of the family court number, principal judge, family court number 3, Kamrup Metro at Guwahati on 25/6/2024. On the basis, upon appearance, the learned court shall fix a date for cross-examination of the plaintiff witnesses. It is made clear that on such date which is being fixed, the petitioner has to cross-examine, else the trial court shall proceed with the disposal of the suit in accordance with the above the instant petition stands.
Lordship, may cross-examination both the parties, Lordship.
What?
Cross-exam, may Lordship both the parties, Lordship, cross-examination in that time, that day, Lord.
Both the parties means?
Respondent and petitioner, Lordship.
I will have to submit my DW.
He has not submitted.
After cross-examination, I will submit.
You want to change the civil procedure?
And Lordship, as page 28, Lordship, my petition, Lordship, the husband has already engaged an advocate before the 100 court, separate from the doctor. Anyways, oblige, DP.
Oblige.
Appellant hearing expired, your lordship, on 12th of March.
For that matter,
Yes, sir.
what happened? You are paying for whom? Understood? You are paying for whom?
I am paying for the appellant, your lordship.
And you, Mr. Sahiwala, you are appearing?
Respondent, yes, my lord, I am not going to give the undertaking, my lord. I may be released from the case.
Yes, we release you better, because otherwise it will have consequences.
My lord, my lord.
This court, by an order dated 11/3/2024, categorically observed that in the circumstance, Mr. A.K. Sahewala, the learned counsel, wants to represent the estate of the deceased, he has to submit an undertaking to that effect. Today, Mr. A.K. Sahewala, appearing through video conferencing, submits that the state council is not willing to give that undertaking. Under such circumstances, this court relieves Mr. A.K. Sahewala from the instant proceedings. Now what to do?
I have also my appellant died here on 12th of March. So he has to be substituted.
Mr. Archoma submits that he may be given some more time to take, submits that he would take appropriate steps. Please the matter to
Deeply obliged, my lord.
Yes, Mr. A.R. Shom. Today there was one matter you did not appear. I allowed it.
Lordship, in that matter, I was not there, Lordship.
You moved the matter. That matter, item number 8 or 9, your name was thrown on.
Lord.
You do one thing. You inform me that person. I've allowed that matter in the absence of the petitioner counsel. You inform that counsel, your client, whoever it is,
Lordship.
that it has been allowed. We have fixed the date before the trial court.
Yes, Lordship. Item number.
What is the item number? Mr. D. Chaudhary was appearing on the other side. Where is that item? Wait. Whole matter.
Lordship, same at 36.
This one, 36.
36, yes, in that.
S. Chauhan,
Yes,
that matter.
Yeah, I'm not here, Lord.
Your
I
name,
know.
you move the matter. A.R. Shom appears on the first
In
day.
this case, Lordship, I'll inform Lordship.
You inform.
Yes, your Lordship, I'll inform.
Because otherwise it will be, that person filed the case.
Yes, Lord.
Yes, tell me, Mr. H.K. Sharma. Tell me, what is this?
My lord, the petition is filed against the
What is the IA for?
stay, my lord. That has been
Huh?
stay.
Stay for what?
Further proceeding has been stayed. The proceeding has been instituted by me, title suit, that has been stayed.
What proceeding?
Title suit for eviction of the respondent.
Who has stayed?
This court.
Why you have filed 151?
For stay, Lordship. Prayer is for stay.
Grant stay of the further proceedings of title suit number 38 of the 03 during the pendency of the revision. You are asking for stay of the suit.
Yes.
Why? TRP number here. What is the order you are challenging?
Case 41.
Order 23, Rule 3, 1. Whether he has satisfied the trade. What did you ask? From the above, I am giving the consideration of the package held that the ground shown by the the ground comes up the view of common. So you have challenged this order. Then
Lordship,
what is your ground? Praying to withdraw and file a fresh suit in respect to the same. Learned counsel submits that the plaintiff did not reduce the original power of attorney of Rohit Kumar to file the suit and produce evidence from the plaintiff and also exhibited a photocopy of the power of attorney. We further added the appellate court in its judgment held that in order to reduce secondary evidence, satisfied this can't be the reason why. Rightly. We don't require that IA for that. We dispose it, dismiss it.
Lordship, earlier decreed, thereafter appeal was filed by the respondent, remanded back, and at that stage,
You should have filed an application for bringing on record that document once it is remanded. Give us secondary evidence. You should have given that. Why didn't you? You can't withdraw this. Hello. Heard Mr. H.K. Sharma, the learned counsel appearing on behalf of the petitioner, Mr. A.R. Shom, the learned counsel appearing on behalf of the respondent. This is an application under Article 227 of the Constitution challenging the order dated 29/9/2018, whereby the application filed under Order 23, Rule 1 for withdrawal of the suit with liberty to again refile was rejected. This court had duly perused the state order dated 29/9/2018, as well as also the application which was so filed. From a perusal of both, from a conjoined reading of both the application as well as the impugn order, it reveals that on the ground that a photocopy of the power of attorney have been exhibited and not the original power of attorney having been exhibited, the plaintiff wanted to withdraw the suit, that too, when the suit had reached the argument stage. In the opinion of this court, the same neither constitutes a sufficient cause, nor it amounts to a formal defect within the ambit of Order 23, Rule 1 of the Code. The learned trial court have duly considered the said aspect of the matter in passing the impugned order, and as such, this court finds no jurisdictional error in passing of the said order, for which the instant petition stands dismissed. Cost. No cost. You didn't appear in the earlier matter, no?
Lord,
I extend it.
my lord, there is a stay, so
What?
the proceeding has been stayed.
Where? You wanted to stay out here only?
No,
You
no,
got
no,
to stay.
Yeah, proceeding has been stayed. In India, IA that was stayed, Lord.
Okay. This court further
12/6
further
2019.
vacates the order dated 12/6/2019 and taking into account that the parties are duly represented, direct the parties to appear before the learned trial court on 19/6/2019, 24. So the learned trial court thereupon shall proceed with the adjudication of the said suit in accordance with law. You can, however, withdraw, not with liberty.
Obliged.
You can, however, withdraw to negative. Yes, yes. What is this? Review? My order? What have I done wrong?
I'm representing respondent number 4.
None appears on behalf of the applicant on call. It is seen, and Mr.
M. Alam.
M. Alam appears on behalf of respondent number 4.
Lordship.
You want this review to be allowed?
Lordship, actually, the petitioner has expired in September 2021, and we have been given possession of the suit land by the wife and son of the petitioner. And we have completed the construction of the boundaries, and we have the complete possession of the suit land. Hence, the matter may be disposed of.
The learned counsel appearing on behalf of the respondent number 4 submits that the review petitioner had already expired in the year 2021.
Sure.
He further submits that in pursuance to the decree so passed by the learned trial court, the decree so passed, possession of the suit land has already been handed over to the respondents
Sure.
by the legal representatives of the petitioner. Taking into account the above, as the petitioner had also expired and none has appeared on behalf of the instant petitioner, the instant proceedings, and there has been no substitution thereafter. None has been. Taking into account that the petitioner had expired in the year 2021 and there has been no substitution thereafter, the instant proceeding stands closed as it has abated. Why insufficient address?
In IA case number 862, registered upon my application under section 146, notices were issued, steps were taken by both ways. Now the office has reported that the heirs of the opposite party number 2 are not to be found, and the report says that.
Wait. Did the person die prior or after? When did the person die? Who died?
Pendency of the revision application, my lord. The pendency of the revision application.
Pendency of the revision, he died. Okay. Now what happened? Notice not served.
Notice not served. Process server has reported, my lord, that notices could not be served as the respondent does not stay in the address mentioned in the petition, and the house has been given on rent where they used to reside earlier.
You are staying where?
Lordship, earlier I was appearing for respondent number 2, Lordship.
Who died?
Respondent number 2.
Then?
Uh,
Why you are appearing? For
Respondent
host?
number 1 is also there, Lord.
Oh, one on. Who is respondent number 1 and 2?
Dear brother, sister, Lordship.
Okay. You know where the sister is?
Sister
is there?
No, sister,
No,
Lordship.
brother is dead, my lord.
Brother is
Five
dead, Lord.
siblings.
The brother is dead.
Lordship.
And she wants to serve whom?
The heirs of the deceased.
Heirs of the
Brother.
deceased.
You know your niece where they are?
I'll have to, Lordship, that
Okay,
instance,
Mr. A.R. Som, the learned counsel appearing on behalf of the petitioner. On behalf of the respondent number
1, Lord.
1, submit that taking into account that the respondent number 1 and 2 were brothers and sisters, he shall intimate this court as to the correct address of the legal representatives of the respondent number 2. List the matter when? How much?
Lordship, at least 15 days, Lord.
15 days, okay. After summers, vacations?
Lord.
Okay. List the matter again on 17th of July 2024.
Oblige, Lord.
Service not complete?
Complete, madam.
Complete?
Sir, 16/5
Service complete. What is this? CRP? IA? IA for what?
delay of 5 days.
5 days. Okay. Heard Ms. So the learned counsel appearing on behalf of the petitioner, applicant, and Mr. And Iqbal. Here Iqbal appearing on behalf of the respondent. This is an application for under Section 5 of the Limitation Act for condoning the delay in filing the accompanying revision application against the judgment and decree dated 13/9/2019 passed by the Court of the Learned Civil Judge Bongaigaon in title appeal number 5/2019. This court have duly considered the reasons, and in the opinion of this court, the same constitutes a sufficient cause for condoning the delay of 5 days. Accordingly, the delay stands condoned. The registry is directed to register the accompanying revision application and list it for motion on such day. Well,
Thank you, Lord.
After vacation?
Okay.
As on such date as deemed fit by the registry.
My lordship, copy of the revision petition may be served.
Ah. A copy of the revision petition be served upon the learned counsel appearing on behalf of the respondent, and the names of Iqbal be shown in the cause list when the revision application is registered as appearing for the respondent. Huh? Where to where?
My lord, I'm praying for transfer from Tinsukia to Kamrup Metro.
Why?
Because two cases are pending in Kamrup.
So what?
One is the maintenance case.
Hmm.
Petitioner has filed, which is pending before the family court, and next date is on 1st of July. And another one, domestic violence case, which he is also appearing, and which is also on 1st of July.
May I submit? On the last occasion, I was directed to take instruction from my client. Lordship has given me two options, whether this case may be transferred from Tinsukia to Kamrup, or I will be facilitating the expenses so that he can be attending the Kamrup Metro family court. So my client has informed me, let your prayer be considered, Lordship, because I'm a very petty businessman. I cannot afford the expenses of my wife for traveling. I cannot afford lot
You cannot bear the expense of your wife for traveling,
for traveling.
but you will have to bear your own expenses for traveling.
Yes, because Lordship, there is a domestic violence case pending in Kamrup Metro. So anyways, I have to appear.
Therefore, administrative goes the learned counsel appearing on behalf of the petitioner and Mr.
PV Kakoti.
appearing on behalf of the respondent. This is an application under Section 34 of the Code of Civil Procedure 1908 for transferring the title suit M1 number 112/2016 pending before the Court of the Learned Additional District Judge FTC Tinsukia to a court of competent jurisdiction in the district of Kamrup Metro, Guwahati. The parties before this court, the counsel appearing on behalf of the parties before this court have submitted that there are two already litigations which are pending before the court of the principal judge, family court Guwahati.
Family court number 2.
Number 2, Kamrup Metro at Guwahati, between the same parties. It has also been submitted by the learned counsel appearing on behalf of the respondent that if the title suit number title suit M112/2016 is transferred to the court of the principal judge, family court, Guwahati, the said respondent has no objection. Accordingly, this court transfers parties shall appear before the learned court of so and so, court of the family court principal judge family court on number 2 on 17th of July. You file your written statement. Have you filed it?
No.
You've been state for all this while.
Yep. Ex parte was given, then ex parte was vacated.
File the written statement on that day without fail.
Yep.
For Lodhima Court authoritative email 23 chapter 123 and 5 is complete.
Service complete?
No, regarding respondent number 4, I was asked to obtain the new address that has been fixed, and I have filed the appeal that is complete.
We respond number 4.
4 is the respondent number 4. I was asked to obtain the new address that has been fixed, and I have filed the appeal that is complete. 5 is the respondent number 5. 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 5 is the respond
What is the matter about?
I filed a title suit against respondents regarding the execution of performance, specific performance. Accordingly,
And?
that was executed, decreed in my favor. Thereafter, my lord, I wait for execution of the same. Subsequent thereto, my lord, the respondent had executed another title suit against me in challenging my title, saying that the respondent theory who have executed the state in my favor did have the title. In that proceeding, my lord, there was a section 39 application that the court will have directed to make the statement.
And what is the appellate court order?
That has been appealed. Page 95.
So there is an injunction for you not to enter.
Yes.
There is no status court.
Page 93.
So your case is that after getting a decree in your favor,
The respondent instituted a challenging my
you got a sale deed in your favor through the court.
the execution proceeding was pending, and during that time, my lord, the respondent filed another title challenging the decree passed in my.
Who is the respondent?
He claims to be the owner. Respondent number 1 here claims to be the owner of the decree because he inherited.
Who is the plaintiff in the next suit?
Respondent number 1 here?
Only one.
Yes.
Not 4. Why is 4 necessary? Why are the others necessary?
My lord, rest of them have been stuck up. 5 to 81, those have been stuck up.
No, otherwise, why these respond number 4 and all these things are necessary? The injunction has been obtained by one person, the plaintiff. Then why is it necessary for others? And what is the ground on which he has filed the suit?
The respondent from whom I took the sale deed, my lord, they didn't have the right to
Maybe.
get the.
If that is so, why Order 21 Rule 97 was not filed? How is the suit maintainable?
That aspect has been taken in my detail.
Understood, you have taken it. Why you are not arguing that? How is the suit, second suit maintainable in view of Order 21 Rule 97? Here he has to show a better right. You cannot file another suit once a suit has been filed. Other person is a third person. He has been held by in silver line. Then, what are you going to argue now? You should submit that other respondents are not necessary, strike them out. And argue on merits. And she is there. But the response number 1, okay. We pass the order allowing your revision. Tell me, how is your suit maintainable? Who is your senior? Huh? Where is she?
It's on leg at court number 3.
Okay, we'll take it up after some time. Okay. We allow your petition. Not necessary. Why do we need the response number 4, please? You are against an injunction passed by the respondent against the plaintiff. Response number 1. How is the suit maintainable unless it is a case of a fraud and only anything out there?
That is
Not the case. He says that he has a title. So obviously, then it is to be decided under Order 21, Rule 97. How is the separate suit maintainable? Take it up after some time. Chalo. Yes, what is this mistake for?
We are challenging the order dated 21/04/23 passed in RSA 1/25.
Is an application for restoration. You are dismissed for default.
They already didn't appear on the
Huh?
earlier occasion also. So let the matter be dismissed for it.
Therefore,
I may pay for the response.
none appears on behalf of the applicant on call. The miscase to her. Mr.
S. A. Bhakhtiar.
So appears on behalf of the all respond numbers 1, 2, and 3.
All responses.
Good stop. It is seen that on the, good stop. This is an application filed under Order 41, Rule 19 of the Code of Civil Procedure 1908 for restoration, readmission of the appeal which was dismissed for default. Readmission. Has this appeal been at all admitted? No. It has not yet been appeared.
Not appear.
For restoration of the appeal which was dismissed for default. It's an application under what provision? This is an application for restoration of RSA number 1/2023, which was dismissed for default by this court on 21/4/2023. It is seen from the records that it was dismissed for default by this court on 21/2023. Therefore, it was again restored. Subsequent thereto, again, this court had dismissed the application for default, the appeal for default on 21/4/2023. And it is against that the instant application has been filed. Today also, none has appeared on behalf of the appellant on call. Applicant on call. Considering the above, this court therefore dismisses the instant application for non-prosecution. I stand disposed.
20.
Yes.
I am for the respondent number 1. Last 2 occasions also not appeared.
What is it challenging? None appears on behalf of the petitioner on call. On the other hand, Mr. F.U. Barbuya appears on behalf of the respondent number 1. It is seen that this is an application filed under Article 227 of the Constitution, challenging the order dated 9/11/2022, passed in title suit number 17/2021, whereby the application for stay of the
Title
suit number 17/2021 under section 10 of the Code of Civil Procedure 1908 was allowed, thereby staying the later suit till the disposal of title suit number 126/2020 pending before the Court of the Learned Munsif number 1 Nagaon. Taking into account that none had appeared, this court have duly taken note of the reasons which have been assigned in the impugned order, and from the same it does not appear that the impugned order dated 9/11/2022 suffers from any jurisdictional error. Accordingly, the instant petition therefore stands dismissed.
Obliged.
21.
What is this?
The challenge here is that my lord, the order passed by the the order passed by the that is my lord 7.
Yes.
But
What is wrong with the order?
the land was my lord was purchased by exhibiting a demand in the year 2007. And from 2007 till 2022, he possessing an expenditure rate. And my lord, he paid an amount of 1,00,000. And in the year 2022, my lord, the plaintiff, my lord, he paid an amount of 55,000 and executed a salary that my lord, owner of the land. But the defendant, the present petitioner could not, my lord, execute the sale deed due to some bitterness relation. And all these things are, my lord, I have stated in my objection, my lord. Those, my lord, apartments, they are not considered by the
Is the injunction proceedings disposed of by the trial court? Disposed. What is the order
no,
passed
my
by
lord,
the
the
learned trial court?
Suit is pending, my lord. Suit
Huh?
for declaration of permanent injunction.
Suit is pending, it's okay.
Temporary injunction is first in favor of me.
Huh?
In favor of me.
What is the injunction?
Injunction, my lord, page 44. First order is at page 44, and that was extended by order dated, my lord, 1912. 44 is the first order. 29/4/2020.
Which are the orders?
Page 44.
44.
It depends. Party.
So initially, the order which was passed on 29th of April 2022 is the order by which the respondent defendants have been stopped from entering into the suit land. Okay. Then the next order which was passed was on 1912.
1912.
What was that order?
By this order, lordship, the earlier order was accepted.
And these were challenged in
Yes.
appeal. So therefore, the injunction proceedings are still pending.
Pending.
Then why should this court at all interfere with all these things? How many forums do you want to fight? Let the trial court decide the injunction petition. Whatever orders have been passed by the appellate court will remain till the disposal of the injunction petition. We only direct the learned trial court to dispose of the injunction petition as early as possible, within 30 days. That ends. This is an application file. Under Article 227 of the Constitution, challenging the order dated
7623.
The order
17/6/2023, passed by the learned civil judge Tiptagar in Miss Appeal number 7/2022, whereby the learned First Appellate Court observed that the orders passed by the learned trial court dated 29/4/2022 and 19/12/2022 did not call for any interference. This court, upon perusal of the materials on records, have found that the order dated 29/4/2022 was an initial order of ex parte ad interim ex parte injunction. The subsequent order was an order by which the application seeking extension of the interim injunction dated 29/4/2022 till the disposal of the injunction application was allowed. Under such circumstances, the injunction proceeding being Ms. Case number 53/2022.
21, Lordship.
Huh?
53 of 2021.
21 or 22? Ms. Case number 53 of 2022 arising out of title suit number 37/2022 is still pending. So, under such circumstances, taking into account that both the courts below have already arrived at an opinion as regards the passing of the has already arrived at an opinion, this court does not find have already arrived at an opinion as regards the ex parte order. And this court, finding no jurisdictional error, does not find the present application to be a fit case for interference with the order dated 17/6/2023, passed in Miss Appeal number 7/2022. However, this court also takes note of that the said the injunction application has been pending since long, and as such, directs the learned court of the Munsif number 1, court of the Munsif number 2, Sibsagar, to decide the Mizze case number 53/2022 as expeditiously as possible, and preferably within 30 days from the date a certified copy of this order is placed before the learned trial court. With the above, the instant petition stands disposed.
Obliged.
Service complete.
My lord, service is completed.
You are appearing for everybody.
No lordship, only for respondent number 1.
Why the others? Your sister brothers, who are they?
They have been received, my lord, but still did not accept. And my lord, LCR regarding title appeal is received, but regarding the title suit, my lord, not received.
Huh?
LCR, my lord, LCR regarding title appeal is received, and regarding the title suit, my lord, not received.
Two, three, four are performer. Why do we need them?
Yes, my lord, perform.
Which strike of? Are they necessary?
We have received the note.
Huh? Hello. This court had duly taken note of the office note dated 22/5/2024 and deems that the service upon the respondent number 2, 3, and 4, performer respondent number 2, 3, and 4 are duly complete. This court further takes note of that the LCR of title suit number 33/2010 have not yet been received. The registry shall take effective steps for requisitioning of the same. List the matter for hearing immediately upon receipt of the LCR.
Obliged.
Yes.
We have challenged the order dated 10/8/23.
Oh. Again, these people.
Yes, sir.
Same Lal Babu.
This time they have come.
They have come. Yes, tell me.
The learned court has allowed the petition filed by them for calling the record from another court.
Which order?
The order is at page 20.
Page
20.
Yes. This is which court? Executing? No, suit. This is another suit. That is for execution.
That was disposed of on compromise. Decree was on compromise. And this is another one.
Yes, which order you are referring to?
Lordship 10/8/2023.
Yes, it has many portions. Which order?
The first portion, my lord.
In the petition filed by the learned counsel for paying for colleague for the case because of midday case number 2 pending is stated in the document. Then what is wrong?
The relevant portion is at page 21.
Yes.
Second part. Later on, both sides are represented. Case is big for necessary order with petition number so and so. Heard the learned counsel on both sides. I have perused the case record. It is observed that the instant petition pertaining to dismissal of the suit for non-prosecution, wherein it is stated that PW1 submitted his examination in chief on affidavit without the original documents being exhibited due to which the copy could not be furnished to the opposite party. It is further observed that since 26/4/23, the instant case is pending for cross-examination of PWs due to non-exhibiting the original documents along with the evidence. It is pertinent to note that this court, by order dated 10/8/23, called for the relevant case record from the Court of Civil Judge, Junior Division 1, Sunitpur, Tejpur, for the purpose of exhibiting the original document.
What is
And
this later on business? How many later on can happen?
Lordship, 10/8/2020 on
My lord, first of all, the records were called for so that the exhibit can be compared with. Later on, when the record arrived, the court has compared and returned back the record. And thereafter, they have also filed an application for dismissing my suit for non-prosecution, as I have filed photocopies of the exhibits.
How can it be that? Anyway, then,
That was rejected.
then
And the act of comparing the documents with the case records and thereafter return back the case record, that was challenged by them.
Why?
Lordship, on 10/8/2023, actually it was fixed for passing of the order. On a petition, we have filed page number 65.
Yes, Mr. S. Viswas, come.
Well, we have basically challenged the action on the part of the court, whereby the record from the other cases were called for. It was compared in the chamber itself, and it was exhibited as an exhibit in the main suit. So far as his contention is concerned, never applied for the certified copy. There is a provision in the Evidence Act. He very well could have applied for the certified copy and could have exhibited it before the court. But here the process is
Where is the records?
the records, my lord, so far as
Was it returned back?
returned back.
Why? The records could be returned back later on only.
At same day the records were called for, same day exhibited documents were exhibited, and same day records were called for.
They were seen with the original and exhibit.
Yes.
Yes.
It is only the learned presiding officer and the counsel for the other side were present and documents were marked, exhibited.
Why was it necessity for returning the record?
Because the case
Because
is
the case
pending.
is still pending, it's going on.
The case is
yes.
pending.
The
So
period,
that was returned.
yes. But here the orders seem to be very strange. On 10/8/2023, when we filed a petition, our petition according to the institution disposed of. The fixing 28/8/2023 for record. So later on, when they pursued the matter, then later on again one order was passed. That is the relevant case record being misdemeanor case number so and so received, and the original documents sought to be exhibited in the instant suit are proved in original with the compared copy.
How is it possible when you fix another date?
That's all.
Otherwise, they have scope to call for the record at the time of
No, they could have very well
cross-examination.
filed a certified copy of the document. There is no objection. Certified copy is very well can be accepted as an exhibit by the court. So far as the original records are concerned, when these were called for, exhibited.
No,
even-
I'm not on that. Court may call, return it back because the matter is pending, can be done. But when there is a date fixed on 28/8, how could the record come immediately and then
Yes.
they come and then send it back?
Yes, this is seem to be very strange. And then another order was passed on the same day later on. Both sides are represented. Cases speak for necessary order with respect to petition number 1565/23. Well, this is the petition your lordship will find at page 98. This is the petition which was fixed on 21/7/2023, by which we filed a petition. If I may take your lordship to page 98.
'98 is the same order on different.
That is, both sides are represented. Seen a petition bearing number 1565/2023 filed by the learned counsel for the defendant, wherein prayed to dismiss the suit for non-prosecution, showing cause herein heard and perused. It was fixed on 10/8/2023 for necessary order. As per the business of the day, it was fixed for necessary order, but on the day 10/8/2023, they filed a petition number 1693, wherein the learned counsel for the plaintiff prayed for calling of case record. Then several orders were passed during the course of the day. We are not aware about those orders. When we check the record, we found the number of orders passed later on.
Documents were compared in the presence of the learned counsel of the other side.
No,
also,
no.
my lord.
It was, my lord, admittedly, it was exhibited compared.
Yeah, first of all, when the case was fixed on 28/8, I don't understand how could the record come immediately? Is it possible? Is it heard of? In civil litigation, most of you call for a record and the records come immediately. You verify, you send it back immediately. Everything is happening immediately. How is it possible?
Because for last some dates, for some last dates, the plaintiff could not file the original one, could not bring the original one.
Understood. Everything is understood. But how could you get the records?
Because within the same campus, my lord.
So what? Your order is passed on 28/8. On 10/8, fixing 28/8 for record. And if it is on 28/8 for records, this order needs to be typed out, signed, and the record immediately comes in. This record has to come from the court of the civil judge, junior division. Number one, a requisition has to be sent by the solicitor of that court to that particular solicitor of that court to get it. That's the new. That is how the procedure is. How is it possible you sign the order, wherein you are fixing on 28, the records come all of the year, the court verifies it and does everything. This is very unnatural.
He has the scope to cross-examine on that aspect, my lord.
Rule 13.
And if
Order
required, he can call for the record, my lord.
No, I'm not on that rule, order 13, rule 10. I'm not on that. But isn't this a procedural
Yes.
mistake committed by the
Irregularity.
court? How could this record come in? Whether he could have given the certified copy of those documents or not, that is a different aspect. But how could the court compare on that date in absence of you? And we will construe that it is in absence of you because the date initially was fixed on 28/8.
My lord, that page 21, letter on both sides represented.
Understood, but how is it possible?
Well,
This court now needs to take up this matter with a pinch of salt, a judicial proceeding with a pinch of salt. Is it ever conceived of? You have been practicing in the civil court, or have you ever seen anything to that effect? A case is fixed on a particular date for record, the records come before signing even the order itself. And he makes a comparison and again pass it on. Later on, records come, I verify, and again I send the record. This is a case where I think an explanation should be asked from the judicial officer. How is it possible he has done that? And that too, it is categorically mentioned on 28/8. Is the same officer still there in Punitpur, Tezpur?
It's been transferred.
So, this is an application under Article 227 of the Constitution challenging the order dated 10/8/2023, passed in title suit number 90 of the 2014. This court upon perusal of the impugned order dated 10/8/2023, is shocked and surprised in the manner in which the said order has been passed, inasmuch as the same infringes on the judicial propriety. The reason why this court makes this observation is that an application was filed for calling for the records pertaining to Mise case number 155 of the 2014, which is pending before the Court of the Civil Judge, Junior Division number 1, Punitpur, Tezpur, entitled suit number 90/2014. This application was allowed, thereby calling for the records of Mise case number 155/2015 pending before the Court of the Civil Judge, Junior Division number 1, Punitpur, Tezpur. The learned trial court fixed the matter on 28/8/2023. However, most surprisingly, the records of the Mise case number 155/2014 immediately is received by the trial court. The trial court then compares the records of the said Mise case number 155/2014 and again sends it back on the same date itself. It is also seen that by the same order, some other proceedings have also been disposed of. However, this court is not concerned with the others. But as regards the calling of the records of Mise case number 155/2014 and then comparing the said records and again sending it back, this court interferes with the order dated 10/8/2023 to the said extent. And accordingly, directs the learned Court of the Civil Judge, Junior Division number 2, to call for the records of Mise case number 155/2015 and then by fixing a particular date, and on that date, upon receipt of the records in presence of both the counsels, the exhibits, if any, is be marked. Accordingly, this court therefore disposes of the instant petition with the above observations. The interim order dated.
No interim.
No interim order.
No.
There is an interim order.
The interim order. It must be there.
22/9/2023.
Huh? No, there is no interim order. No interim.
But the suit is stayed, my lord, pursuant to an order passed by the same learned civil judge The latest
Oh, good
part,
stuff.
page 23.
Taking into account the above, this court therefore disposes of the instant petition and further directs the learned trial court to proceed with the suit after observing the above formalities as so directed. Taking into account both the parties are duly represented, the matter will list the parties are directed to appear before the learned trial court on 21st of June 2024.
Already fixed on 19th of
19th of June.
Pilot one correction with that. Miss J case number was 155 of 2014. Not
Yeah, 14.
Yes, my lord, here, IA number 1283, that is for condemnation of delay of 10 days due to death of that Virendra Chandra Ghosh, who is the appellant number 1. So there was delay of 10 days and they did not know that the legal aspect is substituted. That we have mentioned at page 5, para 3.
You are paying for?
All the respect.
How much delay?
10 days.
For?
For
Condoning
filing substitution petition.
substitution. Where is your substitution?
Yes, substitution petition is 341. IS number 34123.
And
this delay is 1283.
there is only substitution. No application for setting aside abatement.
Apartment. Of that. Your worship, if this is substitute apartment. 10 days. 10 days.
Understood. See, with 90 days being over, it abates. That abatement has to be set aside. You don't need a condonation application.
But I remember one court expressed the view that if condonation, it will automatically come. So that if you're lordship on that, then I shall file another IA for apartment.
My lord, this 341, my
Oh,
lord,
it
that
is
is
an application. Yes.
341, my lord, that is substitution petition that has already been disposed of prior to condonation of it. That is the order dated 10/3/23, my lord, that reflected that there is a 14 days delay. 10/3/23. And my lord, in order dated 28/8, my lord, it is recorded that it is filed in time.
10/3/20. 20 years.
And it has not been listed. In that, your learned counsel for the AR submits that he may be allowed to file necessary application in that.
Then the next order, my lord, 28/8/23. Second or third day.
An application under order 23 rule 3 saying for substitution the application is filed within time, therefore 10 days is the same substance out.
My lord, here is
This
so
is
many
appellant number 1. Who died? Appellant.
So many IS are there. So because
Now who died? Mr. Mahmood?
my lord, Virendra Chandra died.
Appellant or respondent?
Appellant.
Appellant number 1 died.
Virendra Chandra Ghosh also died. Then respondent Lulu Kumar Agarwala, he has died. So many IS are there. All are allowed excepting these two.
Which two?
These two. That is one substitution and another is condonation.
Kaun allowed?
So many IS. Yeah.
2952/2019 was, my lord, for appellant number 2. Delay condonation of 1907.
We are concerned now with Lulu Kumar Agarwal.
No, my lord, that has
No.
been allowed. Respondent
Allowed.
number 4, yes.
That is allowed.
Okay.
Only, my lord, appellant number 1.
That is for?
341, my lord.
That has already been allowed.
Yes, my lord.
41.
This was pending at that point.
So then if that is allowed, I think this condonation is in fact. The main case may be listed for hearing.
Taking into account the order passed in order dated 28/8/2023, passed in IA Civil 341/2023, comma, the instant application has become infructuous, for which the instant application stands closed. And the best part is, on the same date, the same judge issued notice in this application.
There is a confusion arises. Already 4 persons have died due to pendency of ticket. So
Okay.
On the same day, my lord, all the IAs were displayed.
no,
Main case, huh?
it is
This court
one
have
of
duly
the-
noted that various appellant as well, various appellants as well as the respondents have expired during the pendency of the instant second appeal. The learned counsel appearing on behalf of the appellant is directed to file a fresh memo of parties before the registry of this court by 3rd of June 2024. So on the basis of them, the registry shall make necessary correction on the base taking into account the orders being passed in various interlocutory applications, and also update by making and also updating them in the CIS.
Obliged.
Yes, you have to take
Lordship, the office to
Who is number 2?
Lordship,
Who is number 2?
who is the brothers of respond number 1, Lordship?
1, 3, 4, 5,
Yes,
6.
1, 2, sir, they are legal heirs of Surendra.
The 2 you have to make them substitution done.
So I do not think that they have to disclose it. Respondent, they have appeared from the office to
Others have appeared.
other appear, but they are they know about the legal heirs of the respond number 2.
Preparing for respondent 1, 3, 7.
1 is the brother of respond number 2. Find out who is the legal heir. Give the name. Mr.
S. Dipusa appearing on behalf of D. Chaudhary.
Huh?
S. Dipusa appearing on behalf of D. Chaudhary.
B. Chaudhary.
D. Chaudhary.
Mr. So-and-so, Mr. D. Mr. So-and-so, the learned counsel appearing on behalf of the respond number 1, 3,
1, 3 to 7.
4, 5, 6, 7, and 8.
No, not 8, sir. Only
So 7. Submit. No, Mr. R.K. Bhuya appears on behalf of the applicants, and Mr. So-and-so appears on behalf of the respondent number 1, 3, 4, 5, 6, and 7. From the office note dated 16/5/2024, it appears that the respondent number 2 had expired. It is also seen that the respondent number 2 is the brother of the respondent number 1. So taking into account that the counsel is already representing the respondent number 1, this court have directed the state counsel to provide the details of the legal representatives of the respondent number 2. List the matter again on 26/6/2024. You inform.
Yes.
Can you inform early? Because then otherwise another problems will arise. You'll have it on. How much time will you take?
3 weeks, sir.
Where are these people staying?
I have to ask my senior.
Huh?
I have to ask my senior.
You'll ask your senior, I'll ask you where. I'm only asking whether there is a mobile tower out there.
They're in Kamrup.
So the mobile tower is there. We'll have it on 10th of June. Get your information.
By LA appeal, my lord, there was a delay, my lord, 345 days, my lord.
Ah,
Additional affidavit filed by me, my lord. Earlier, but the similar matter has been already, my lord.
yes,
My lord, I am appealing for respondent 3.
you
My
are
lord,
opposing. Are you opposing?
My lord, I have to show a certain thing because the delay is actually, they are asking, praying for only 345 days.
Hmm.
And the original affidavit, in the original IA, they had stated that it was 345 days. Now in this, they are saying 338. And in the impugned order, I counted just now, it is 1000 days.
I think you
So
should
they have
file
to
an,
bring some connection with the impugned order.
so you file an objection.
My lord, impugned order is...
No, Mister, you have to file an objection. These are very serious things.
Yes.
And these type of orders would not help you.
And the impugned
And
order
I am, after 100 days, I am very strict.
the actual delay is 1000. The impugned order, my lord can have a look just now. It is annexed with the LA appeal because it is in the court paper, certified copy. So I think this thing goes on that only. This is certified copy, my lord. And nobody
Certified
can have any
copy
say on this.
when?
That page. It is annexed with the appeal, LA appeal. It is. It started.
No, Mister. When did they file it? When did you file it?
In sometime in March 23.
My lord, it was filed, my lord, 4/3/23.
4/3/23. Why you are catching? Are you deducting 715 days or not?
Lockdown.
Yes, but then they.
I think, Mister.
State, no, my lord.
Huh?
The petition in the IA.
Not necessary. Can't we take judicial
They have
notice?
stated that is they have stated for 1 year, my lord. That also they have stated.
Understood, but Mr. Bachcharji, tell me one thing. Are you not supposed to know that there is an order being passed on 10/1/2022 by the Supreme Court holding that the period from 15/3/2023 2020 to 31/5/2022 has to be excluded? The amount area, the total amount comes to 715 days. So all dates has to be done. Now 21/12/2019 is the order. Once it is 21/12/2019, he has time till 3 months for preparing an appeal. And that appeal period would have ended prior to 15/3.
Yes.
Okay. So that some period was left there. Then again, after that, he gets this certified copy on 25/4. So from 25/4, his period is there till 31/5 plus another 4-5 days. So it will be around 4th of June 2022. It was filed on 4/3/2023. So isn't it less than 365 days?
Yes.
Yes.
My lord, that is all right, but then at least the two IAs are there, one affidavit. That also the number of days are different. One says
What
it is
to do, Mr. Bachcharji? If I was there, I would have correctly mentioned. Mr. H. Das has the habit of not doing it properly. That is why on the last occasion I said that I would not condone his therefore sought for time for filing an additional affidavit. Now he has come up with that additional affidavit, understanding what he should do.
It can't be both, my lord.
Yes.
One day, that at least he has to satisfy, my lord.
So
that
what
is
do you
all my
want?
objection.
What do you want? You want to file an objection?
So, my lord, if the COVID period is explained and if my lord is happy with the...
I am not happy. I am asking you whether you have a right only.
Yes.
Do you want to concede or not?
No, my lord, I do have the objection that the number of days is different in everywhere.
No, forget about what they say.
Yes.
We will go as per the court, what the court had stated. The registry
So
has
then I'm coming to the additional affidavit. The
It is
reasons...
330. It is 338 days.
Yes.
Yes. Then
So they are saying that they had some difficulty regarding the contacting the lawyer.
Whom?
That is the
Which
only
lawyer?
cause there. Yes.
Showing
Which
Gwalpara.
lawyer?
They are in the Gwalpara.
So,
So thereafter, she came to know, and my lord, after getting the amount, awarded amount, my lord, my lord,
when did you get the awarded amount?
in the month of December 2022.
December 22,
Yes.
you got the amount.
Got
Then
the
you
amount.
realized that the reference has gone against you.
Yes, my lord.
Huh?
Thereafter, thereafter.
Are you raising any eyebrows upon your earlier lawyer?
Yes, my lord. He has informed that if you are not satisfied with the awarded amount, you can file appeal before the Honorable High Court, my lord.
Then
This was subsequently she read it and came down to Guwahati and filed this case, my lord.
you didn't meet them in Lok Adalat or somewhere.
No, no.
Because most of your explanation is when you go to visit Borpeta, you find
Learned
out your clients
Along
out
with
there.
the Learned Council of Gwalpara, he has come here, my lord. She is
Huh?
the remote place of Dudna area, my lord. Tribal woman, my lord, he has no knowledge, did not have any knowledge, my lord. And communication gap also there, Dudna area, remotely.
What?
Dudna, my lord. Gwalpara district, Dudna, in remote place.
Communication gap?
Along with the advocate, Learned advocate of Gwalpara, my lord. Not with me.
No telephone.
Subsequently, no, my lord. There is no communication along with
How much my amount are you getting?
only, my lord, 63,000, my lord. And it is 90,000, it has been calculated, my lord. Initially, it has given 45,000 per bigha, my lord. It is enhanced to 90 bigha. And it is in marketed, it is 30 lakhs, my lord.
How much you are getting? The
90,000.
huh?
90,000.
Only 90,000.
Only one bigha.
And how much do you want?
3 lakhs, my lord, per bigha. This is judgment, cover judgment is there. I have given that. Forestry Doimari already settled.
Huh?
Already settled judgment is there.
Where?
Given the extra fee of this.
Which judgment? Supreme Court?
Supreme Court also subsequently enhanced to 3 lakhs. I have annexed here. But prior to that, forestry judgment was also there.
How is this relevant?
And 2,50,000 already awarded, my lord.
Anyways, you have objection or not?
My lord, I don't have any instructions to file objection.
This is an application filed under Section 5 of the Limitation Act condoning the delay of 338 days. 345 days in preparing the accompanying appeal against the judgment and the judgment dated 21/12/2019 passed in LE case number 16/2013. This court have taken note of the additional affidavit which have been filed, wherein the grounds mentioned, more particularly at paragraph number 4, 5, 6, in the opinion of this court, constitutes a sufficient cause for condoning the delay. Accordingly, the delay stands condoned. In addition to that, this court also takes note of that in similar matters, appeals have already been filed before this court against similar orders, and as such, dismissing the instant application on the ground of delay would not be proper. Accordingly, the instant application stands allowed. The registry shall register the accompanying appeal and list the matter for admission on such date as deemed fit by the registry. I stand disposed.
Yeah, I'm here for responder one. We are the basically beneficiary of it. Okay. Responder one at Railway Department.
Give your name.
Sure.
I have not even put his name.
Sure.
Give your name, everybody's name.
Awesome.
27? I for what?
For detail.
Delay of condon 36 days. Lordship, in the meantime, we came to know that respondent number 2, 3, and 4 died. Therefore, we have again filed substitute petition.
That has not come on record.
Yes, Lordship,
Isn't it?
Lordship,
Who needed it?
yes, Lordship.
Then what happened? Notice issued.
Lordship, no.
Today, sir, I'm representing the respondent number 1. Today, sir, I received the sufficient copy. Lordship, the, the respondent number 2 and 3 already expired in the year 2000, but in the year 2000.
2000?
Yes, Lordship.
24 years back.
Before, prior to the filing of this CRP. Also, I'll file an objection.
কি গান নতুন আয় কি নতুন আয় না এই নতুন আয় কিখনত নোটিছ ইছ্যু কৰি দিওঁ শুরু করেছো what is this IF for yes. The counsel appearing on behalf of the respondent number 16 for an accommodation for filing objection against the applications. Hey, application could be done.
IN number 1239.
Only one.
There, Lordship, IF file, one is filed for state of further proceeding, but not.
What is this IA for?
One I is for filing, first I is filing for delay control. Justice 2390, 23.
Hey, দেখুন দিয়ক না
After again,
2390 is for 36 days.
Delay.
We are not done. Where is the IA for this? IA is for these applications to Order 22 Rule 4. How are days maintainable without your applications?
Lordship, this is for substitution.
Huh?
1, 2, 3, and 24 is for substitution of response.
Understood, madam. She says these persons died in the year 2000, 24 years back. Are you not required to file any application for that? For setting aside abatement for the purpose of condonation of delay? Then, the learned counsel appearing on behalf of the applicant submits that she requires further time to take appropriate instructions. This is the matter of 2 months. File those applications immediately. Because abatement also the period goes on. You have to file that immediately. I've given you 2 months. That's a different thing. Yes, Ekman. What is this for?
This is an application for non-alienation of the suit property.
Huh?
Injunction against alienation of the suit property.
Injunction?
Milord, one thing I have to point out.
Yes, you are not filing objection.
I am filing objection, but appeal is admitted on 28/11/2020 without framing any substantial question of law, Milord.
Huh? Oh, this is what?
This is
You are filing Order 39 Rule 1 and 2 for staying the judgment.
Actually, it's not for the state, for stopping the alienation of the property under Rule 1.
Oh, eto নহব এনেকুৱা দেখক এটো দেখক The learned counsel, I put your blame that the court made the mistake. The learned counsel appearing on behalf of the petitioner appellant submits that inadvertently this court had admitted the instant appeal by an order dated 2011-2023 without formulating any substantial question of law. He therefore submits that the instant matter be listed at the stage of Order 41 Rule 11, who's taking into account. This court have also taken note of the order dated 2011-2023, wherein the appeal has been admitted without formulating a substantial question of law. Taking into account the above, lists the matter on 12th of June 2024 at the stage of Order 41 Rule 11.
Okay.
Yes, why you are not appearing before the Lozima court?
My lord,
There was a false
Then?
offer. My lord, in compliance with your lordship's direction on 1st of May, my lord, registry has reported completion of service on respondent number 1, Roman 4, my lord. He has in fact appeared by filing Wakalatnama,
Then?
and only thing instead of writing.
Yes, signed as Anna Prabha
Yes.
Das instead of Anna Balada.
Wakalatnama
Then,
is
which a false affidavit, a false Wakalatnama filed by whom? We asked her to be present in
there.
person.
No, Lordship. Her name is Prabha. uh,
Anna Prabha Das.
Yes, sir.
Then why did she sign as Anna? Or they have put the wrong name.
Yes, sir.
Then correct it.
I'm allowed to correct.
Mr. C. Sharma, appearing on behalf of the respondent number 14, submits that the name of the respondent number 14 is actually Anna Prabhadas and not Anna Baladas. And as such, the Wakalatnama has been signed as Anna Prabhadas. So taking into account the above, the appellant herein is directed to file a fresh memo parties before the registry of this court by 3/6/2023, making due correction to the memo parties.
Lordship, more two names are wrong. 3A, it is given as Sanjit Das, that is Horrendo Das. 3A. And Lordship, 3B, Timothy Rita Das, that is Rita Kolita.
In addition to that, it is also being pointed out by Mr. Shi Sharma that the names of so and so have been wrongly mentioned as so and so, which ought to have been so and so. Full stop. The appellant hearing, the counsel for the appellant hearing is directed to file a fresh memo parties by 3/6/2024 by correcting the due names, and on the basis thereof, the registry shall make necessary correction in the records as well as also update the same in the CIS. Has it been admitted?
Yes, sir.
Yes, you have appeared.
Yes.
What is this matter?
My lords, we had prepared an application under 12(6) to record certain admissions and therefore a pronouncement on judgment by way of admission. The learned trial court records all the admissions. My lords may have page 7A, which is the impugned order.
Where?
Page 7A, my lord. Internal page 7A. The learned trial court records all the admissions, then goes on.
Mr. Counsel, are these Sandillas connected with that Aparajit Sandilla doctor?
Aparajit Sandilla Datta.
He's a doctor.
Doctor.
Yeah.
Yes, yes.
I
In
won't
fact,
take it up.
it is his land.
Okay. List the matter before any other petition.
Right.
Lordship, the
What is it?
respondents were supposed to file their objection by 22nd.
Filed it.
They have filed it yesterday. I have received a copy.
Okay, very well.
24th I filed, my lord, but was
Anyway.
Copy was served upon me yesterday.
Then, what is this for?
It's for condonation of 250 days of delay in
How?
filing the affidavit.
It is not on record. Okay, list the matter again on when do you want it?
As early as possible.
As early as possible. On 5/6/2024.
Can it be on 4th, my lord?
Why?
I have some figure.
6/6/2000. No, not 6, 7. 7/6/2024. taking into account that the objection so filed by the respondent is not on record. The registry shall bring on record the
Take your pleasure.
I have filed my for vacating the expiry order of the state and the landlord. I have filed a suit for rejection because of default. 2008. Suit was decreed. They filed appeal, appeal dismissed. Thereafter, they had a revision. No amount has been paid to the date. He is claiming at first position in the WS without the construction. And suit has been decreed in my favor. Appeal file, appeal dismissed. Now,
landlord tenant.
landlord.
No,
I'm the
I have
landlord.
denied the tenant.
Huh?
I have denied. I have denied that he is not the owner. You know, my lord, I have filed an affidavit in opposition in the IA.
Then it has been held that you are tenant.
It is held. That is held.
That
And
you are
I
a
have-
tenant.
Yes.
Then,
I have filed the revision
then why have you filed a revision?
because not properly decided. Issue number 4 was not decided at all.
No, then why have you filed a revision?
The
Are
revision
you, wouldn't that be a case under second appeal? If you are denying the title,
denied the title.
then
Here is the main question that he claimed that he has purchased the land. It is
anyway, I say too late in the day. You take it out, you'll ask somebody else or not. When do you want it? We'll have it on any Thursday. and
Any-
This is to me, otherwise tomorrow.
Fine.
Tomorrow, 2 o'clock, we dismiss this.
No, my lord.
A fine day tomorrow. Weather seems to be better.
Tomorrow, not my lord. Tomorrow.
Tomorrow.
Day after tomorrow.
Tomorrow.
No, my lord. I shall be out of tomorrow.
Tomorrow.
No, there, no, I shall
Okay, we vacate the stay.
No, my lord. Here is various pertinent question.
Pertinent question
Your
is
lordship
that
will
first of all, you have filed it under, you fall it within ambit of landlord tenant. Why have you filed the revision? That is why I have put you a specific question. Why have you filed a revision? The moment you file a revision out here, are you not admitting that you come within the ambit of the order of, it comes within the ambit of the Assam Land and the Assam Urban Area Rent Control Act, and therefore you are barred under Section 8 to file a second appeal. If you are denying the title of the plaintiff,
No, I have denied.
then
Page 34.
page
34.
34. Let us see his written statement. What does
That
it
is
say?
page 34.
Your lordship will see it. Your
Ah.
lordship will see that.
Performer defendant failed to refund rupees so and so and has taken him, and the performer was a habitual repeat drinker.
My written statement.
Husband of the performer defendant allowed us to live here for a
Of the
short period.
defendant,
Without
now
any-
let us see how does the trial court decide
So your lordship will see it.
whether the issue is there or not.
That
Yeah.
Issue number
Issue number
four was
3,
not
whether there is a landlord relationship of landlord tenant. How does issue number 3 is decided? Whether the defendant occupied the place against the will of the performer defendant and acquired self-possession. Both the issues are taken up. Get the tenant in cross-examination, she reports that her husband used to work at Rongia and he used to travel from home from Myanmar. PW5 during resided as a tenant for 10 to 12 years in the disputed house. And suppose that he resided upon the by forcefully entering into the suit land and he has not purchased the land. DW1 admitted that before purchasing the land by the plaintiff, he entered into the land. He further deposed that and to mention that the defendant is claiming hostile land on the land. It mentioned that here the party who they however want to So, by that, don't you think that this is a case on the for second?
I have filed application for converted.
I can't convert.
It can be converted.
I can't convert it. Revision can't be converted into a second appeal. Second appeal, you see, first appeal, it's a different thing. But second appeal is not. Second appeal can't be done.
Liberty.
There will be many aspects will there.
Liberty. Liberty.
Huh?
Liberty.
Liberty has to give, obviously will be given, and the period during which the incident will be excluded. But you can't file a because your specific ground is that you are not a tenant.
That is why here is the pertinent question.
No, the pertinent question is, but how do I decide that? How can you decide once you file this? Wouldn't you be stopped now to say that in view of the bar under Section 8, I am filing a revision?
Yes, yes. I understand.
And then you are having a problem, then you can't raise that issue of title here. We are therefore to go on the special. You have a case because issue number 3 decided by the learned trial court has been not in a proper manner. It has not been decided. I don't know how the appellate court, but 3 as decided by the learned trial court has not been done properly. So under such circumstances, your specific plea is hostile possession. Whether you are able to prove adverse possession or not, that's a different aspect of the matter. But that is one of the cases. But can this court enter into that aspect of the matter in 115? No. And you are stopped.
Liberty.
Huh?
Liberty may be
Hello. Your order also gets vacated.
no, automatically it would go order. That order would stay order would automatically go if the but the liberty may be given. I can file the second. That may be-
Mr. P. Upay, the learned counsel appearing on behalf of the petitioner, submitted that taking into account the specific stand which have been taken by the petitioner in the instant proceed, in the suit proceed, to the effect that the petitioners are possessing the land in the house or house?
Only house premises. I have said that you have not purchased my premises.
He said, look, he's claiming that I have purchased the land.
Only land.
The land, house was not mentioned. That is why he's claiming that I have not purchased the house. He is possessing the land as a permissive possession of the original owner. I have purchased the land along with the house. And he said that in the sale deed, house was not mentioned. That is it.
That the building.
Other person are giving land to me. After purchasing the land, other person has land has been metered in my paper. The holding has been transferred in my name. I have proved that. He is claiming he is possessing the first floor of the house. He is claiming that he is possessing the land on the
Ground floor is yours.
Ground floor is my location.
No,
So already all tenants are here. They are occupying the land, paying the rent to me. They have
not
the witness. They have deposed that we are paying the rent to me. Only he is claiming that he is possessing the land on the permissive position of the original owner, and he is paid
not a
50,000. Permissive position.
No.
Kindly see the base.
No, you see. Where is that?
Yes, he says that he entered into the land, but did not pay any rent.
Yes.
That is his stand.
During pendency of the suit, my vendor has died. His wife has examined as a witness. He said that he is paying rent. He transferred the land to me. He is paying rent to the husband of the original owner.
So did anybody give a notice to him that you are now the owner?
Yes. They have given notice to him that I am
Did
the
you prove that?
No, I never.
Did you prove that notice?
Notice. Not verbal notice.
What verbal notice?
All tenants has paying rent.
No, there is no other.
All tenants has been examined.
Not
Seven,
but not the tenant.
3 tenants has taken.
Yes, I have got the record. You may.
Anyways, Mr. Upadhyay, I fixed it next week. Think about it, what to do. I'm not withdrawing it today. Think about it. Because if it is a case of adverse possession you want, Within the ambit of 115, you cannot reach.
I agree with your lord.
No, you take a call. Think about it. I can have it tomorrow or day after. You think about it as to whether you like to withdraw or not. Because if it is a house where you are not claiming any right into the land, but the house, can you have an adverse possession in respect to a portion of a room of a building?
This is the identity of the house. The land is quite separate.
Huh?
This is that is what. Without claiming the land, can I claim the part of the building?
Can you?
Without claiming, I am not claiming the land. But
No, you
I-
think about it. We'll have it on Friday. Just think about it as to whether you like to withdraw or not. Okay? Otherwise, if I withdraw it tomorrow, you may have some problems.
Yeah.
Think about it, over it.
Yeah.
Huh? I think better off. Because if I do that, taking into account that it is a house where a part of the building you are occupying.
Yeah.
Yes. If we
Whether it
see
is under
Article
the separate
65,
identity or not.
you see Article 65, then it will say recovery of an immovable property. Immovable property may include a house also, a portion of the house also.
Yeah.
There's no quarrel with that.
Yeah.
But if in the circumstance that you are a tenant and you withdraw it, and later on you may have it, because today I may pass an order, then tomorrow you may be in difficulty. Just think about it properly. Okay. List the matter again on 31/5/2024 at the top at 2 p.m.
My lord, there is interim.
The interim order passed earlier shall continue to.
Early hearing, my lord, 16 matter.
Mr. Kadir, say it's very difficult for me. Let this matter come up next week. Because I would not like to fix a date unless I am there. I may not be there. I'm not there in this bench from next week onwards. So it may be I may not sit in this bench for another 4-5 months. Happy for you people. Yes. Let's the matter on 6th. Is the matter on 6th. Is this within time?
Lord, I filed an application for implement of the applicant number 1 who has expired, my lord. It is within time. Your lordship will take 1496.
And what are the other eyes for?
Other way, my lord, my learned friend possibly not ready today. That is 611. We have
Direct
filed
the
an-
learned dissenters in so pay the land compensation amounting to 53 lakhs pertaining to so and so.
My lord, this petition is pending before the district.
So this IA is for
implement of, my lord, applicant number 1.
why?
Who expired recently.
You are what?
I
You're
am
the
the-
respondent?
I'm the respondent in the second appeal. An applicant in,
And who has filed this?
my lord, I have filed this.
Why?
Because the application I have filed, your lordship will find IA 611/2044.
Huh?
There are 3 applicants. Your lordship kindly take 611.
Yeah.
This is where applicant here. Your lordship will find at page 4. Nirmal Borkakoti, then number 2 Srimati Lakshmi Borkataki, and
Who are they?
total 4. They are the applicants, they are the respondent in second appeal. Now,
Then why are you filing?
because, my lord, unless the Nirmal Borkataki's respondents are here, legal are here, my lord, this application will maybe not non-maintainable. Because they are the 4 respondents. He is also get one share of this particular 53 lakhs and odd. So therefore,
Understood.
for our my lord, interest we have filed. In fact, they should have filed.
We have to file a lordship substitution petition in main second appeal.
We
I
have
have received
provided
the
all the
legal-
materials to them,
So Nirmal Bokotoki having died,
my lord.
other persons are there here.
Yes, yes. No, my lord, he is the legal heir. Is my lord, your lordship will find.
Now understood. These legal heirs are
In IF 1496.
Vikram Bokotoki, Rashmi Rekha Bokotoki, A and B.
A and B.
Now, A and B are not parties earlier.
No, they are not.
Okay. So, if Nirmal Bokotoki has died, how can you file an application?
My lord, otherwise my application will be. Your lordship will find that I have filed an application for, my lord, directing the district judge to pay this amount to these applicants, because their suit was dismissed, appeal was also dismissed, as they do not have any title.
Why should I direct the district judge?
Because otherwise, my lord, he has kept it pending for
what?
apportioning the this compensation.
What is the second appeal for?
Yes, second appeal, your lordship will find.
Against what?
This is, my lord, both the suit and appeal was dismissed. Their plaintiff suit and appeal.
How does it has any relation with the apportionment?
Because they are thinking that the district judge is thinking, because it has gone.
District judge will be most probably in respect to land acquisition.
Competent authority is sent there for the apportionment.
Understood. But isn't that a proceedings which is separate from a suit proceedings?
Is exactly, your lordship is very correct. But district judge is not understanding that. He want to distribute it to all the, my lord.
Understood. So it has to be filed, whatever may be. Don't you think that there is a requirement for filing a reference application of whatever may be before the district judge under, if it is under the National Highway Act under 3H?
Yes, yes, 3H.
You are 3H.
And it has been referred, my lord.
3H for 3. And the district judge has to decide that.
Competent authority has referred
So,
to the district judge.
Then
now the competent district judge is thinking, since their name is also there in the Jamabandi, so therefore they are also the competent to get the compensation.
So then if that district judge passes an order, there is an appeal lies against that.
But if that order is passed apportioning, then my lord, I will be prejudiced because this is my land.
Understood. But for that proceedings has to be decided. How can this court pass this direction?
My lord, I understand your lordship may be very correct on that. But then if your lordship decides the second appeal once for all these matters will be over. So therefore, my idea is, if your lordship take up the matter, I mean the.
I'm not there. I may not see.
My lord, when your lordship will be available.
I am not available. I may not be available in this bench.
In the meantime, I have to file substitution petition also.
I am not be available. I can't now fix it. I am not here. I knew that I would not be there.
Can I pray, my lord, that you, since your lordship heard it,
Where?
you should keep it part.
No.
This is the only way, my lord, the matter can start. My idea was that
I have kept only 3 parters. One is a matter of that yesterday, that matter. No? The whole day I was taking up one matter. That is one partner. There's another partner which is a very interesting question of law involved. Is as to what as regards 2.2, section 2.2 of the Hindu Marriage Act, with it was a case of this missing community. One of the person filing a suit for divorce under the Hindu Marriage Act, can they do so in view of 2.2? And there is one other matter pertaining to land acquisition of that particular medical. A morgue has been taken for the last 50 years.
It's 2 matters. This will be
3 matters.
This will be number 3.
No, this is second appeal. I can't. Don't be proper. But you see this application, how do I do it? When did the Nirmal Bokotoki die?
I think February. The month of February.
24th February. So I received notice on 9 May. Lordship, within 1 week or 2 weeks, I will file substitution. Means second appeal.
Anyways, we do one thing. This is an application filed by the applicants who are the legal representatives of the respondent number 1 one Mr. Nirmal Bogotoke,
Yes.
who expired on 24/2/2024. Bor Kakoti, who expired on 24/2/2024. Taking into account that the instant application ought to have been filed by the appellant. However, on reasons, on the grounds which have been assigned, this court converts this instant application as an application under Order 1, Rule 10(2), read with Section 151. For impleading the legal representatives of the respondent number 1. Order 1, Rule 10(2), Section 146 and 150. Accordingly, as Ms. P. Bhattacharya, the learned counsel appearing on behalf of the appellant, submits that the appellants ought to have filed this application. And she further submits that the right to sue against the legal representatives of the deceased respondent number 1 also survives. Accordingly, this court implead the applicant, the legal representatives of the respondent number 1 of the accompanying appeal, whose names are mentioned in paragraph number 7 of the instant application as respondent number 1A and 1B. The counsel appearing on behalf of the appellant is directed to file a fresh memo of parties on the basis of this instant order by 5/6/2024. And on the basis thereof, this court, the registry shall make necessary correction in the records as well as also update in the CIS. This court further taking into account that the legal representatives of the respondent number 1 have already been brought on record, dispenses with the filing of an application by the appellant under Order 22, Rule 4. With the above, the instant application stands allowed. So many provisions have been. Yes, new case, 6 weeks notice. Yes, 48. How do you explain? Oh, what is this 48 business? Oh, you wanted to withdraw?
Yes, your lord. The executor has died and the beneficiaries are not made a party.
Huh?
The beneficiaries were not made a party.
Mr. H. Buragoin, the learned counsel appearing on behalf of the appellant, submits that the appellant has died, no? No.
Executor, the respondent.
Submits that the executor who have been granted the probate having expired and the beneficiaries having not been made parties, the appellants herein would not like to further press the instant appeal. Accordingly, the instant appeal therefore stands closed, stands dismissed on withdrawal. Records, if any, will be returned. Yes, Mr. Mahmood. Yes, I remember from the morning on. Yes, there's a mistake committed by this court. It was something like that. Mahabharata, it happens now. Asostama auto. The last verse, it goes very small. He said, application very slowly. On that. Because while I was seeing that video on that day, everywhere it was saying, but then he said application. I for witness here, na?
But
What
I
am I
for
doing
equal-
for it?
The main case.
This is for restoration, na? Okay. This is an application for restoration of the testamentary appeal number 3/2017, which was disposed of by an order dated 17/5/2024. This court upon this court, the learned counsel appearing on behalf of the appellant submitted, applicants had submitted that the applicant only wanted to withdraw IAC 930/2024 and not the testamentary appeal. However, this court had inadvertently observed that the appellant had withdrawn the testamentary appeal. So this court have also taken due note of the contents of the instant affidavit and had also perused and also gone through the live streaming of the date 17/5/2024 when the instant application instant proceedings was taken up for withdrawal. This court duly acknowledges that there was a mistake so committed by this court in passing an order for withdrawal of the testamentary appeal, inasmuch as the prayer so made by the applicant was only by the appellant was only for withdrawal of IA C 930/2024. Consequently, as the mistake had been committed by this court and it being well settled that no party should be prejudice on account of a mistake by the court, this court therefore recalls the order dated 17/5/2024 passed in testamentary appeal number 3/2017. The testamentary appeal number 3/2017 therefore I had to recall the order dated. Accordingly, the instant interlocutory application stands allowed to I main testamentary appeal. In view of the order passed in IA number 1591/2024, the instant appeal is restored to the file of this court and fixed for hearing.
there is also a substitution will come.
And be listed. On 19th of July 2024
Hello.
for further orders. Now, what to do with this order? This is disposed of. 930, no problem.
No,
930 is okay.
now, but in 930, order was passed as the yesterday appellate also. So both your lordship's order will follow, will be corrected in both IA and as well as the secretary appeal.
He আগৰ অৰ্ডাৰটো আৰু এটা লিখি দিব। It is also seen that IN Civil 930 was also disposed of on the basis that the accompanying testamentary appeal number 3/2017 taking into account the order which have been passed in IA 1591 of so. The order dated 17/5/2024 passed in the instant application stands modified and the instant application stands withdrawn.
That means 930.
Huh?
930 may be treated as withdrawn.
Is withdrawn at the request of the learned counsel appearing on behalf of the petitioner. Yes.
Office note says that the order of this court is duly communicated to the respondent. They received the same.
It has been brought to the attention of the court that the respondent herein have been duly communicated about the pendency about the order dated 23/2024 passed by this court. However, the respondent has not appeared today. Accordingly, the matter would be listed again on 5th of June 2024 for consideration of the condonation prayer of the instant condonation app.
Right.
Yes, transfer from
Matter was 16th of the last day.
the
transfer was filed by the wife lordship.
for the respondent
of the
seeks an
Guardianship Act.
accommodation till 29/14 instance.
Lordship, it was dismissed, but then.
What?
I did not take any time for
Huh?
the last time I appeared, it was dismissed.
It was dismissed?
Yes.
What dismissed?
On last Friday, the matter was this transfer petition was dismissed.
It was dismissed on the
On-
on the ground stating that the minor girl child was residing with his father, and the mother has filed the guardianship case was to be transferred to Kachar,
From Hailakandi to Kachar.
Hailakandi to Kachar. But considering the distance, it was directed to appear before the Hailakandi court.
Aye. This
Yes.
court, no, the last order is of 24/5/2024. The learned counsel for the respondent seeks an accommodation till so to obtain instruction. That is the order. Transfer P3 number 6/2021.
It's 6
Huh?
2021.
2021.
Arundhati Das versus Kripa and Paul.
Huh? What did I do?
It was dismissed. The
Oh.
transfer was not considered.
The order. The child is with the father.
Is with the father.
Oh, maybe I said all these things, but at the last I gave some opportunity, may have been. That is why this order is not there, na? There is some other, not a regular steno who has taken. Nivedita could have taken. Anyway. So, it is with the father. Father stays in,
Hailakandi.
you stay in
Kachar Lord.
Kachar. Case is filed in
Hailakandi.
Section 9, Guardianship Act.
Right.
So it cannot be transferred. Isn't it? Hello. I think I passed an order, I forgot. Transfer matters, that is why this happens. Most probably, I must have said that I won't give it to this guy. And she was a new stenographer. Anyway, this is an application for transfer under Section 24 of the Code of Civil Procedure 1908. And this is an application for transfer of Miss Guardianship case number 5/2020 from the court of Hailakandi to Kachar. It is relevant to take note of that the minor. Oh, I remember. I gave this dictation because one was one child died
Yes.
and one
The
child
son
was alive.
expired.
Yes, I remember it. Yes, I gave the dictation. Good guy. Go.
The
Miss
order
A Bora, A Bora, the learned counsel, A Bora, the learned counsel appearing on behalf, and Miss S.S. Bora appearing on behalf of the respondent. This is an application under Section 24 of the Code of Civil Procedure 1908 for transfer of Miss Guardianship case number 5/2020, pending in the Court of the Learned District Judge Hailakandi under Section 10 of the Hindu Minority and Guardianship Act 1956, as well as the Guardianship and Wards Act 1890 for appointment of the declaration of the guardian to the respondent, to the declaration of the guardian in respect to the minor, Srimati Dupati Paul, daughter, and Sri Dibjoti Paul, son. It has been submitted by the learned counsel on behalf of both the parties that who died?
Son died, Lordship. Son.
that during the pendency of the instant transfer proceeding, the Dipjuti Paul expired. Master Dipjuti Paul expired. However, the question now arises as to whether this court can transfer, should transfer the proceeding from the court of the district judge, Hailakandi, to the court of the principal judge family court, Kachar. Isn't it pending before the district judge?
Yes, the stay was there.
This court takes note of that Section 9 of the Guardianship and Wards Act 1890 categorically mandates that the categorically mandates put below.
It is shown as revoked, Lordship.
Huh?
The order is shown as revoked. After it is thing as disposed, thereafter it is shown as revoked.
Is it?
Yes, Lordship.
Section 9 of the Guardianship and Wards Act stipulates that the court, the jurisdiction to file an application seeking guardianship shall lie before a court where the minor ordinarily resides. So, taking into account that the minor is presently residing with the respondent at Hailakandi, and the statutory mandate in terms of Section 9 of the Guardianship and Wards Act 1890, this court is of the opinion that the instant application cannot be. That this court is of the opinion that the instant application cannot be permitted. This instant application has no merits for which the same stands dismissed. Interim order is not there, na? Or interim?
Interim was there.
The interim order passed on 19 to 2021 stands vacated, and the parties are directed to appear before the learned district judge Hailakandi on 15/7/2020.
Apply.
Well, madam, how is the suit maintainable?
The decree which was obtained by them, there is a prayer that the decree is a fraudulent decree. Lordship. That prayer is also there, right, along with right title.
Maybe. What is the fraud?
Lordship,
Fraud is that you are the owner of the property.
yes, Lordship.
So, it is the case under Order 21 Rule 97.
But a separate suit was filed within it.
You cannot file a separate suit. There is a bar. There are lots of judgments.
Lordship.
How can you file that?
I am not ready today, Lordship. In fact, I have not gone through the file today.
Okay, tomorrow at 2 p.m.
At 2, Lordship.
2. So, today, now I won't pass an order. Tomorrow at 2.
Friday, Lordship.
No, tomorrow at 2. This can't remain like this. How is it possible? Get all of that judgment. There are 4 judgments of the Supreme Court which says a suit is not maintainable.
Lordship, can it be
And one
Friday
is
to-
Justice
there
Punchi.
is a problem, Lordship. Friday, Lordship.
No, Friday I have no time. Friday I will take up very less matters, taking into account that I have signed, and thereafter I am no more there in bench 1 most probably for long.
Then, your Lordship, after returning back, tomorrow I have some difficulty, Lordship.
Let her do. But you can't help it.
Lordship.
The law is against you.
Lordship.
You can't file a suit. The suit is not maintainable. Okay, Friday.
Friday,
At 2.
okay. My
You are the only counsel.
Rest of them are out.
Chalo. Then it is in your favor to get it out. This is the matter on 3rd of June.
कैसा रहा ठीक है ऐसे करते हैं आप